IDCO was the main opposite party, and notice has already been solved on them.
Notices have
Yes,
served on notice
Yes.
number 2 and 3.
yes, ma'am. And
Who are
then
they? Who are they? OP number 2?
number 2, IDCO, Mr. Bhuya's name was showing. Mr. Vivekananda Bhuya's, my senior advocate, his name is showing.
Name is appearing.
Yes.
This application has been filed for restoration of WPC number 12800 of 2013, which is to dismiss for default, dismissed for non-prosecution by an order dated
10th of August 2022.
1/9/2022 or 23. Pay some cost
My lord.
token from the order sheet of WPC number 12800 of 2013. It appears that on repeated occasions there was on repeated or once?
Once, first day.
Considering the averments made in this application, the same is allowed. Let WPC number 7 so be restored to its original site.
Item number 2.
Item number 2 may permitted to it. Give us.
This is that matter where I had mentioned several times, the opposite parties are interested to give us the pendency. There are two matters. One got disposed of. My case is pending. Lordship will take it up Monday.
I mean, pardon to mention, my lord. Let's say fresh item for a fresh admission for.
You give your slips, please.
My lord, I mean, pardon, my lord, in item 44, I declared my lord's kind.
We will be committing a sin if we do not take up your matter today.
May I prefer the matter fixed at
We will take up. Just it's for the other side.
my lord, senior advocate, Mr. B. Rautra. Item 44, my lord.
We'll take up.
Yes. Pardon to mention, my lord. My lord, item 3 and item 6 of the list. My lord is senior.
First of all, let the slips be. Give your slips, all slips. Restoration, yes. Give your slips.
May I be pardoned to mention one matter? It's a tender matter.
Give your slips.
Yes.
Item 17 from an inverse.
17.
Pardon to mention, my lord. Item number 41 may kindly be taken up, my lord. I am for the respondent and government is for the appellant, my lord, because stay order has been granted to that extent. So, with the permission, kindly.
I will take up your matter, but you will have to satisfy us
Yes, ma'am.
that other matters are not
No,
required to
I-
be taken up.
My lord, subject to your
Yes.
satisfaction.
So you tell us that these are the matters which are
No, no,
unnecessarily,
I can,
which have unnecessarily been listed. So don't take up those matters and.
No,
take
no,
up-
I can say, my lord, to that extent, with more to that
So
extent.
what is there? Is there any urgency?
No, so far as, because the stay order has been granted by the stay order has been granted by.
Have you filed any application for vacating?
Yes, my lord, and also a counter for final
You
disposal.
want your interim order to be taken up? Which item?
Item 41, my lord.
41. The order was ex parte, interim order was ex parte.
Ex parte.
Ex parte interim order.
Yes, my lord.
Are you sure?
My lord.
Are you sure that the
Ex parte,
order
that ex parte order, my lord. At the time of admission, stay order has been granted, my lord.
was?
You mean to say state had filed it within time?
State Raksha file within time, my lord.
Very rare.
I have filed my counter to that extent, my lord.
All right, it will come for orders.
Ah, your lord, yes.
Your Lordship,
Okay.
WA 1331 of 24, I have mentioned for the 5 times, but it is not.
IA, there, your IA is not there, he says.
So far, the counter I have filed for final disposal. my
Mr.
lord.
Counsel, there is an interim order of stay.
Yes, my lord.
You are aggrieved by that order. So have you filed an application?
Much
then make a
obliged,
mention.
my lord. Much obliged.
So I beg pardon to make a mention, my lord. Item number 22, my lord, senior was mentioning is typing for the respondent. Item number 2, my lord.
Odisha Public Service Commission matter.
Kindly taken up due to personal interference. I pray, my lord, let it get taken up any other day, my lord, on behalf of Mr. U.K. Sama.
Yes, you can do that.
That matter, your lordship had directed the government to give its response to the
Oh,
affidavit.
that regarding
Yes,
dentist.
Yes, my lord.
So, in the meantime, the government has constituted a committee to look into the matter with different members of different departments.
Very good.
That committee is going to be held on 8th. May I pray this matter may come after vacation so that
Yes.
in the meantime, they will take a decision, your lordship.
Your Lordship,
As jointly requested on behalf of the parties, list this matter on
This is the instruction I have received.
9th October, 9th or after,
After vacation.
on 22nd,
Yes.
on 22nd, within first 5 cases. First of, Learned AGA representing the state Odisha has submitted that a committee of senior officials of the government has been constituted to look into the circumstance arising out of the recommendations made by OPSC for appointments against the post of
Dental surgery.
Dental surgery.
dental comma based on which the appointments have been made. Post op. The instructions which he has received, copy of the instruction which he has received has been furnished to this court, which has been taken on record. The written instruction, copy of the written instruction which he has.
Pardon to my lord, those 11 candidates who are now to face the subject to panel outcome of the committee. Those candidates are not party before this one.
We understand that.
Yes. Yes.
We understand. And we have, we don't intend to, that they should be removed. But some solution is to be worked out.
Yes, ma'am.
So that, so that no person has any grievance.
Pardon to mention, well, item 3 and item 6 of the list, my learned senior, Mr. Samir Kumar Mishra, 3 and item 6.
Yes.
Learned senior is down with fever. May I please?
How much?
After a week after.
On it.
Pardon to mention a matter, Your Lordship.
Yes.
In item 1 of this list, we have received the affidavit yesterday evening. So we could like to take instructions from BMC. I'm appearing on behalf of BMC in item 1. So,
Let it be called, Mr. Please wait.
May I pardon to mention, my lord, item 25, fresh admission of the matter 2023. Due to my personal inconvenience, kindly take up after the.
Your Lordship, WA 1331 of 24, I have mentioned 5 times, but it is not being listed. I'll be obliged if it is ordered to be listed sooner.
Mr. Had you filed mention slips?
Sir, I have five mentions. Last one, day for yesterday.
Each and every mention slip has been considered by me personally. And I don't know what has been done, but some order must have been passed. So either your mentioning slips would have been rejected, and I don't know.
Unit is very urgent because it's a arbitration matter and beneficiary measure. Old arbitration matter, your lordship.
Give your slip again, I will see.
My lord, item 43 of the today's list, that is writ appeal, it has been special. It may not reach. May I pray for Monday? It may be
Don't
taken
know.
up.
This is the Mr.
The urgency is, my lord.
You should not make such mentions. If it does not reach, then tomorrow see what can be done.
Tomorrow is Friday, because the urgency is, my lord. The candidates are going to be appointed on 5th, my lord, other candidates. That is my
All right, we will see.
predicament.
So according to you, the case will not be taken up today.
May not, because specific
Just a
postings are
minute.
there. I humbly
According
submit.
to you, the case will not be taken up today. Therefore, the case should be taken up tomorrow. This is your submission.
Nah, if at all it is not.
You can make this mention tomorrow.
Along with my learned seniors item, my identical, this is identical case. Lordship, may kindly take it up together.
Which item?
Item
43,
my
ma'am.
lord.
We should.
Here, my lord, the urgency is, my lord, the state government has violated your lordship's direction and going to give appointment.
Maybe.
That is what the urgency is.
Maybe that. Let me see. Let me see.
Pardon to make a mention, my lords.
Give your slip, please.
For orders item number 31.
I'm dealing with OP number 224, my lords. A writ petition was filed and this honorable court disposed of the writ petition by the order dated 5/9/2009. And due to non-appearance of the counsel, the then counsel for the opposite party number 224, the recovery order has been quashed. Similar matters are pending before the Honorable Apex Court, my lords. As until today, batch of a series of cases. And cases are pending before this honorable court, and this honorable court in one of such cases transferred the matter to the Honorable
So
Apex
what do you want? Item number?
31.
That order, that case has been disposed of in terms of another case.
Another case, but all the batch of similar type of batch of cases, my lords, that are pending before the Honorable Apex Court. This is regarding double line stitching machine.
Or it has no.
File application for recall of order.
Recall.
No, but if that application has been disposed of, it can't be transferred to the Supreme Court.
No, so that's why I filed a petition for that order, my lords. Because due to non-appearance of the council, this order has been passed.
No.
We then
Non-appearance. In absence of counsel.
OP numbers 2 to 4, Full Corporation of India.
2 to 4.
State and petitioners were heard.
Yes. 2 to 4, you have filed a counter.
Counter. Yes. After this recall along with the counter, we have filed a counter.
So after the disposal, you have filed a counter. Brilliant.
Stating therein that similar type of matters are pending before the Honorable Apex Court. As on date, it is pending, my lords. Batch
So
of cases.
counsel, when did you file your case?
15/5/2010, my lords.
15/5/2010 for
Recall of that order.
which order?
That order dated, my lords, 5/9/2009.
5/9/2009. Under which provision of law?
That time I was not the counsel. Simply it has been filed, my lords.
Simply you filed. It's a disposal of matter. How could you file an application for recall?
No, your lordship will dispose of the matter. That's with that Apex Court on that those cases. This will,
That part we don't have.
no, your lordship simply dismiss this application. Recall.
This practice will have to be discouraged. Filing of applications after disposal of the matter for recall of the order. Interlocutory application. So we will forget the meaning of interlocutory.
This begins a review
In
should
course
have been
of time.
filed. Review should have been filed instead of recall.
No,
of that order.
whatever. this application, ID number, what is the number?
Missed case number 6 of
6256 of 2010.
Filed for a recall of an order dated 5/9/2009, whereby WPC number 3145 of 2003 was disposed of. Stop. This application in a disposed of matter, in the court's opinion is not maintainable, cannot be entertained, and is dismissed accordingly. Stop. The petitioner shall, however, be at liberty to make appropriation in accordance with law if he intends to seek recall of the said order. Opposite part number 2 to 4. If the law permits. Yes.
Item 32.
Wait, my lords. May I have your lordship's permission to address my lords on BC? This is, my lords, an application that I am filing in terms of an order passed by the Supreme Court. Your lordship may please have page 20.
Where is the application?
Yes, my lord, this is an application amendment. This is IA 5589 of 2024.
What for?
What happened? So it's quite a checkered history, my lords, if I may say, in this matter. This is a writ petition of 2012. Your lordships had directed status quo to be maintained. The other side defeats your lordship's status quo, goes ahead and constructs a building on the premises. We move contempt. Contempt was pending. Contempt ultimately doesn't get heard. Thereafter is disposed of. We go to Supreme Court against that. Supreme Court has passed an order requesting my lords to hear it and has interfered against that order. And my lord, that is the order that I want to invite my lord's attention to in this application. It's the first annexure at page 26. My lords have IA 5589 of 2024, the first annexure to that, my lords, page 26.
That application copy has not been served now.
Application
opposite party for IDCO, my lord. They have not served the copy. And all the pleadings are also over, my lords. Complete.
May I invite my lord's attention to 26?
The original application, the application is still pending.
Yeah, the surprising part, my lords, is this matter is not listed despite an interim order and the respondent continues flouting it. So the Supreme Court has made an observation in this, requesting my lords to take this up on a basis, my lords, if I may say.
No.
What
do you mean that the matter is not listed? Surprisingly.
Yes, I'm so grateful. I'm so grateful, my lord.
Did you file? Did you mention for it to be listed?
Yes, we had.
Where are the mention memos?
My lords, may I just take 2 steps back before I point out those mention memos? This matter is a bit.
And Mr. Panda,
my lords,
have you carefully gone through your amendment application?
I have.
The Supreme Court permitted you to make prayers for taking action for commission of for contempt proceedings, and there's an alternative prayer that has not been permitted by the Supreme Court.
That, my lords, with my respectful submission, please see page 27. Has been given in my respectful submission. Kindly see 27.
Yes.
Please see the 3rd paragraph on that page in view of the aforesaid. That's how it begins.
Yes.
We believe that the petitioner may suitably amend the writ petition for an alternative land plea which will be considered on its own merits, looking to the facts and circumstances, including whether there was a restraint order which has been violated.
Yes. So that is the facts and circumstances of the case.
I bow down. So, well, my respectful
Please read the next sentence.
No purpose will be served in restarting contempt.
Yes.
So, my lords, my respectful submission is this.
All right, we will hear your unnecessary.
Yes, all I'm requesting would your lordships issue notice.
All right.
Let them file their reply.
Copy has not been served.
I'll do that during the course of the day. I'll do that. I don't know why they're saying they haven't been served.
Who are the opposite parties?
Well, so this is IDCO, Industrial Corporation of Orissa.
IDCO, who is appearing?
And State of Orissa.
I'm appearing for IDCO.
You served copy on IDCO?
I have, my lord. That is my instructions. I'll ask my instructing counsel in Orissa. They said it was served. I will just check this up and your lordship may take
counsel.
Pardon me, my lords?
Are you a senior counsel?
My lords, no, my lords.
No, so you have instructing counsel.
My lord, I am appearing on instructions, my lord.
You do not have instructions whether copy has been served or not.
No, my instructions were it was served. That's what I'm saying. Since your lordship is the other side is saying they're not served,
all right.
I'll be done during the course.
All right, yes, who is for the IDCO?
I'm appearing for IDCO, my lords. And my lord, one thing also.
Who are the parties?
Other-
If your lordship will see, there are 7 respondents.
Please wait.
Yes.
My lord, one fact is also, your lordship may kindly note that, my lord, here in
We
this
will not note any fact.
My
We
lord,
want
another
to
review
expedite
petition
hearing,
is
that's
pending.
all. It's a 2012
My
matter.
lord, another review petition is pending arising out of another writ petition which has been disposed of, and same order has been challenged. That was challenged in the earlier writ petition. That is also
All that
challenged.
will have to be
All right,
gone.
we'll see.
I pray that may be
We
also
will-
tagged, my lord.
We will see. First of all, we will see this application.
But let them serve a copy, my lord.
This matter for admission on 23rd of October to be listed within first 5 cases of
That's 23rd. I mean, some
observation made
difficulty
by
may request the week after.
the Supreme Court in the order dated 15/9/2023, passed in SLP bracketed C diary number 34530 of 2023. Stop. Copy. Let a copy of the writ petition and the pleadings be served upon learned counsel representing IDCO. IDCO.
Itco, my lord.
My lords.
IDCO bracketed opposite parties number
3, my lord.
opposite party number 3. And
I'm applying for 1, 2, and 4.
have you received?
No, no copy. has been
Let
served.
copies of the writ petition be served on learned AGA, Mr. Samantha, learned AGA, who writes opposite party number so and so.
1, 2, and 4.
The-
Mirrors.
2,
1, 2, and 4.
1, 2, and 4. Any other opposite party?
Where private opposite parties are there, Mirrors.
So, my lord, those will become academic because the Supreme Court has indicated in it what the indication has come. I don't think I'll have to then press against the private parties. That's the sector of
There,
the
no, there is a prayer in the writ main prayer in the writ application which set aside the orders of allotment in favor of the opposite parties.
Or delete them.
Yes, that's all I'm saying. That will become academic.
File an application.
Supreme Court. I'll do that. I'll do that, my lords.
Or learned
May I
counsel.
only make one request, my lords? Instead of 23rd, would my lords consider 25th, 23rd, 24th? I've been a part heard, my lords. That will continue in 25th, my lords, Friday.
This is impossible.
My lords, just a day later, 2 days later, that's all I'm requesting.
Learned counsel appearing on behalf of the petitioner has submitted that opposite parties number 5 and 6.
No, no, 6 and
5 and
7.
6.
6 and 7. 6 and 7.
7.
Private parties are 6 and 7.
6 and
6
7.
and 7. That he shall be filing an application for deleting
My lords.
opposite parties number 6 and 7 from the area of stop. He shall be at liberty to do so. Stop. Who is for 5? Who is
Why will
appealing for 5?
we call, my lords?
If we call Mirrors, there must have a council.
You must have a nominated counsel.
Separate
Your
counsel.
is
They
permit
have
me.
separate
I'll
counsel.
serve them.
Mr. This writ application was filed in 2012.
My
You are
lords.
not in a position to say whether the notices were issued or not.
My lords, that's what I'll get.
Whether opposite party number 5 was noticed.
It was at that point of time the orders were passed. That's my instructions. I will verify this again.
Very difficult, Mr. Counsel. This is not the way.
You are the
You are not sure.
You have to
My
know.
lords, in 2012,
Sorry.
my lord, somebody else was appearing in the matter, my lord. The council. That's why I'm saying I'll get this verified, my lords.
We will see.
Very well. May I only request, my lords, instead of 23rd, would my lords
Sorry.
consider it 2 days later? 24th?
Sorry, Mr. Panda.
Item number 33.
Very well, my lords.
For the reasons we are not inclined to pass any interim order of stay, as we are inclined to expedite the final hearing of the writ petitions, it goes without saying that the rights of the respective parties shall be subject to final adjudication of in cases. All interlocutory applications stand disposed of. Mr. Rao, you have not filed any application for us.
I have filed, initially I have, along with the writ petition, I have filed one IA. And thereafter, I have filed another IA, 6594 of.
That application was filed for amendment.
Amendment
And
and
in that
also.
amendment, you made a prayer for interim also.
And I have
That
not
IA
pressed
has
that.
been, you said you will not press. So you will be at liberty to make a fresh application.
I have said that for the time being, I will not press. That is the order.
So, but that
That's right.
IA has been disposed of.
IA has been disposed.
In any case, your lordships are facing final disposal, so I don't think that will be necessary for us.
Let us see. Let us try to expedite it.
Yes, that is.
And we have taken note of that, the Supreme Court's decision, and we have distinguished that.
This is for the fault
revival of the
It was in different facts and circumstances,
CNPL application.
taking into account the provisions of the CPC.
There is only one. There is a division bench judgment of this honorable court which says that interim orders will automatically revive except if there is any development in the meantime, that will be taken care. There are difference of opinion of different.
Absolutely right. See, this is what we have been following. That once an application is dismissed for default and is restored, then all the interim orders revive. Of course, subject to any development in the meanwhile. But here is a different case. Different case in the sense that there was an interim order, and the nature of interim order, you see, the interim order this will continue, but the final. After that, it was dismissed, and thereafter the Supreme Court has remanded. It's different from restoration. Of course, the word restore has been mentioned in the order passed by the Supreme Court.
Because on 19th December, this honorable court has dismissed the writ petition. Immediately within a week, on 28th itself, the issue work, LOA.
No, but
rightly, because they were not issuing work order because of the interim order.
If it is so, because my learned friend said, Millets, if I'm not coming in the way of your lordship discretion, since your lordships have pronounced the order, may I request for a small indulgence? At least, Millets, let them not claim equities, as it may take a little while because.
That is no question of claiming equities. We have observed that we have clearly that.
I believe, Millets, that
the rights of the respective parties shall be subject to final adjudication.
So be it.
So there is no question of. Yes, thank you, Mr.
Grateful.
May I submit that this order your lordships have passed in the writ petition filed by the BGR 17.
In both the cases. In both the cases.
That's right. So I will not be needed to file any further application.
No, both the cases we have.
Can be disposed of that.
Deeply obliged. Great.
So great.
Obliged. Item number 34.
This should be claimed. All developments will be subject to the outcome of request.
Condonation of delay, how much?
Item 34.
Who is there? Surya Narayan Patnaik. Mr. Surya Narayan Patnaik.
Sorry.
Yes.
34, there is a 229 days.
Yes. Issue?
262.
What is the issue?
My lord, issue, my lord, here the petitioner has claimed for regularization of his service against the post of the clerk. Although he was appointed as Peshi Mohri and subsequently regularized. But since he was allowed to continue against, he was allowed to discharge some work of computer work. So that is why he claimed that I should be appointed and regularized against the 4. Although there is a specific statutory rule prescribed where the procedure has been.
The SI has been filed for condoning the delay of 262 days and filing this writ appeal. Issue notice on the matter of condonation of delay. Private parties, how many?
Madam, 1 month.
Okay, so the sole respondent, returnable within 4 weeks, requisite should to be filed within 1 week, list after 6 weeks.
Item 35.
Condonation of delay, what is the delay?
Delay 44 days.
34 you show.
74 days.
No, that says 41 in fact.
Then we are condoning, you are appearing.
Condone.
There is a private
Also
party.
may also look into the maintainability of the appeal.
That we can see.
41 days. Who respondent 4? Are you claiming any relief against respondent number 4? Perform after respondent.
No, but you say that is not me.
Against the first appeal.
How can you maintain? How can you maintain this?
Let it come any other than mine.
No, where is the question of? When do you want? When do you want?
Day after tomorrow.
Yes, ma'am. 1 day as mine.
As requested on behalf of the applicant, list this matter on. The court is, though the present matter has been listed for orders to consider the question of limitation, we are of the obvious view that this writ appeal
First appeal against order.
against all also, you know.
By the education tribunal, whose orders is it?
Statutory appeal preferred against the order passed by the education tribunal. Dismissed by the honorable single judge. Now against that statutory appeal, order passed in statutory appeal, the writ appeal has been preferred. So whether it is maintainable or not.
Statutory appeal. So the writ petition can be entertained.
Was it?
First appeal orders.
Not a first appeal. Is there any decision on this point? Well, it is not an appeal under the provisions of CPC.
No, but it is.
It's a quasi. It is an appeal against. Of course, the writ jurisdiction has not been exercised. Is there any decision on this point? I want to address the issue. As requested, is this matter on Monday?
Item note 36.
Please examine if this aspect has been read anywhere.
24C of the education. The Education Act.
Item number
36.
The appellant in the present intra-court.
I'm for the appellant.
Please take your seat. In the present intra-court appeal as put to challenge. Twenty-five 6/2024. 25/6/2024.
Yes.
in WPC number 38869 of 2020, whereby the petitioner's writ application has been dismissed. From the short facts of the case are that petitioner had applied for the post of fireman against an advertisement issued on 12/12/2014. Fireman in Odisha Fire Service Organization. At the it appears that was measured as 178.4 centimeter, based on which, taking into account, first of taking into account the said height, the petitioner was awarded 55.25 marks. Stop. He was awarded 16 marks against his height of 178.4 centimeter. Stop. After his shortlisting, he was directed to report to the fire officer for completion of formalities before issuance of the appointment letter. Stop. During completion of the formalities, it emerged that the correct height of the petitioner was 174.5 and not 178.4 centimeter, which was initially measured. So stop. The consequence of measurement of the petitioner's height at the time of completion of formalities was that the petitioner's marks against the height was reduced to 14 from 16, and accordingly his total marks and consequently his total marks was brought down to 53.25. So stop. It is not in dispute that minimum cutoff marks fixed for selection was 54.5 marks. So stop. Since on the basis of height, to have got the qualifying marks of 54.5 this court by filing the aforesaid bracketed Order 2006, which stipulates that candidature of a candidate shall be cancelled, comma, if in the opinion of the selection board he is found ineligible for consideration under eligibility criteria prescribed in the order. So stop. London single judge, comma, a single judge, while dismissing the writ petition, has relied on the Supreme Court's decision in case of Sankarsan Das versus Union of India, reported in 1991, volume 3 SCC, page 47. Stop. We have heard Mr. Randaran, senior counsel, appearing on behalf of the appellant, and Mr. Khutia, AGA, representing the state opposite parties. So stop. Mr. Nanda has submitted that that Rule 10.3 of the rules has no application in the application for the reason that the petitioner's candidature has not been cancelled.
Your Lordship, that one, that no rule, Your Lordship said that Odisha fire search method of record and fireman order 2006.
Order 2006. Rule लिखा है. It is order, but the provisions are called rules.
Normally they are called
order,
but it is quoted in that order also rules.
Then what will it be called?
If in the
Clause?
order,
Clause
if in that order the provisions have been referred to as rules, then we can refer to.
Yes, my lord.
Has no application for the reason that it is not a case of cancellation of the appellant's candidature on the ground of ineligibility. So stop. It is rather a case of a revision of marks which was initially allotted to the appellant, subsequent appellants, after the selection process was over. So stop. He has submitted that the actual height of the petitioner is, appellant is what?
174.5.
No, this is your submission.
175.2 by affidavit.
The actual height of the
178.4 in affidavit he has said
175.2.
175.2 centimeter. Oh, stop. An affidavit to this extent has been filed in the present intra-court appeal you have filed or in the writ petition you had filed?
Yes, by order dated 28 of 24 by.
In the present intra-court appeal. Stop. Mr. Mutial and counsel and AGA has submitted per contra that after the it was detected that the petitioner's height was less than what was found initially at the time of selection. Can we go? Comma, no appointment letter was issued in his favor. So stop. He had earlier approached.
Yes.
He had earlier approached this court by filing a writ petition giving rise to WPC number 24753 of 2019, which was disposed of by an order dated 17/12/2019 with a direction to the DG of Police, Home Guards and Fire Services to consider the petitioner's representation and take a lawful decision. Stop. Pursuant thereto, the petitioner's representation was considered and for the purpose of consideration of petitioner's representation, a committee was constituted under the chairmanship of IGP Fire Services Odisha for remeasurement of the petitioner's height. So stop. The committee had remeasured the petitioner's height and recorded it as 174.5 centimeter. So stop. He submits that taking into the petitioner's height as 174.5 centimeter, comma, the Director General Fire Services reached a conclusion that the total marks of the petitioner being 53.25, comma, below the cutoff marks or 54.5, comma, he was rightly declined issuance of appointment letter in his favor. So stop. Next. After having perused the pleadings on record and the submissions advanced on behalf of the parties, the only dispute of fact which has been raised in the present, which has been raised on behalf of the appellant is that his actual height is 175.2, whereas it is the case of the respondent state that based on that his actual height is 174.5 centimeters. So stop. It is the case of the appellant that if the appellant's height is treated to be 175.2 centimeter, comma, his score should be, his score would be equal to the cutoff marks. And cutoff marks, and then he shall become entitled to be, he shall become entitled to appointment based on the process. I'll stop. Next. We are not ready to accept the contention, the petition appellant's contention for the reason, for the reason that, as has been noted above, the petitioner's height at the time of completion of formality was measured and was found to be 174.5. Stop. Later, complying with this court's order, the petitioner's representation was, appellant's representation was considered, and he was subjected to a re-measurement of his height by a committee constituted by the IG. The committee also found his height to be 174.5 centimeter. Stop. In our opinion, the learned single judge has rightly declined to interfere with the decision of the respondents. Stop. We are further of the view that merely because the appellant was shortlisted for appointment, he did not acquire any indefeasible right to be appointed in view of the Constitution bench decision in case of Sankarsan Das Supra. Stop. We accordingly do not find any legal infirmity in the order passed by impugned judgment passed by the learned single judge requiring this court's interference in an intra-court appeal. This appeal is accordingly dismissed. Yes.
Item 37.
Regarding final disposal of the matter, but it's a tender matter. The tender was for treatment of system 2 on our implementation of zero liquid discharge system, including operational and maintenance for 5 years at Rourkela Steel Plant. The petitioner happens to be a multinational company with 95 years of plant building and water treatment, wastewater and industrial water treatment in various municipality and industrial sectors. But it has got 6,000 projects already implemented in time, municipality industrial group globally, with quality and commitment of
Recess at 2 p.m. 2 p.m.
2 p.m. There is another matter. You don't fix it.
We'll try to. It has come for
final disposal.
It's come for on my mentioning for vacation of stay because the prices are holding firm till September end. Thereafter, the goes for. It's a short points. It's not. Won't take much time.
We'll try to take up at 2.
But can I give a fair suggestion, madam? Can it be at 2 o'clock on Monday? The firm date can be fixed so that we can.
May I suggest, let my learned senior begin with whatever points. I have prepared a note. We'll try because it's with great difficulty it's come
Monday
today.
Can be over.
Mentioned for today.
In fact, then we will not be in a position to take up admission matters. So we want to take up admission
Monday, 2
matters
o'clock,
also.
I think 2 days will not make any difference.
Today, let us try today at 2 p.m.
Today, 2 p.m. We'll try. Great.
Item 38.
This case, short point calls for consideration before your lordship whether the law college is coming professional colleges or not, my lord.
So,
That
colleges are professional colleges.
My lord.
Law colleges are professional colleges. They are not unprofessional.
My lord, that is the point before your lordship, because in the state Odisha Education Act, my lord, speaks, my lord, that I have filed.
All right. So what is this matter? Why
That is only
these
because
matters have?
matter about the law colleges, my lord.
No. These matters have been listed for orders. Why?
This I have for, my lord, because I want a declaration of your lordship that law is not a professional as
That
per
is
the
not
law. my lord.
interlocutory. See that the declaration cannot be interlocutory. That declaration can be final only.
Yes, my lord, because
There cannot be interim declaration that
it was the hearing was going on before the learned honorable single bench, and amidst the hearing, it has been noted that it is a professional core college. That's why it is not maintaining. It is cannot be heard there. So it is a divisional bench matter. My lord, Odisha Education Act says government has to notify which are the professional courses. And accordingly, my lord.
So, but why these? Why have these matters been listed for orders?
This I have filed. My lord.
You have filed IA.
My lord.
What is the IA? Therefore, you want.
Single bench, my lord. So that we cannot lose a forum. That is the only endeavor, my lord.
We will decide this way, that way.
My lord, because Act says, my lord, Odisha Education Act says.
Do you have faith in the division bench?
My lord, 100%, but I cannot afford to go before the Delhi. That's the problem. That's why I'm before your lordship, my lord. We cannot being a law college, small college, we cannot afford to go to the far away Delhi, my lord. That's why we are before your lordship that we are losing one forum, and your lordship can decide the point to the registry. Law colleges are not professional colleges as per the Act, my lord. Government has never notified law as a professional college. There is a.
So you want us to decide this limited question,
my lord.
But your relief.
No, my lord. That can be heard by the bench.
And why can't you afford going to Supreme Court?
My lord, your lordship knows that how it is.
How? Let us know.
My lord, they cannot afford that much
Who
of
cannot
money.
afford?
My lord.
Who cannot afford? I have been repeatedly telling everyone that no one can say that he cannot afford, because we have a huge system of legal aid. So whosoever wants, wheresoever, he shall be provided with the legal aid. You cannot say that you don't have resources as on
law
date.
colleges cannot go there, and colleges students cannot go there.
Students can go there.
Because they are not.
Law colleges may have some difficulty,
They cannot.
but the
They are not
students
BPL
can.
category. They are not, my lord, coming under that women or SC/ST. So there is criteria to go. I am, my lord. I am declaring, my lord. I am just not that wealthy. I can afford a Supreme Court lawyer. No, you will argue. That I don't feel fit for that. Well, this is the.
Never do that.
My lord, this is the only point.
Never. You are one of the most competent lawyers we have seen. How can you say that?
My lord, that Orissa Professional Educational Institution Act 2007.
All right. So for this simple thing, whether it is.
Because, my lord, your lordship is burdened with the matters of law colleges unnecessarily when it can be decided by the. So that your lordship can hear appeal, the fine point where something, my lord, your lordship can interfere.
Now we can understand your intentions. You
You want to come back after
No,
the
no.
final order?
He wants to avoid us.
No, not avoid us, my lord. My lord, this law should be settled, my lord. That is the,
We will settle that law.
my lord, that's why your lordship can decide that law is not a professional course and your lordship can take my writ application. Because I have filed two copies, my lord. My lord.
So what was your relief?
My relief is, my lord, Orissa Education Act 1969.
No, what is your relief? Main relief?
In the writ petition, my lord, I am challenging the de-affiliation. Because in another case, your lordship directed no students are before us. So we will not deal with this matter. In one of the writ application, there is a student have come who has already taken admission, and the law university is saying no, their college is de-affiliated after they have taken admission. So that is the main case before your lordship. And this is the case, my lord, where I am pressing, because why? My lord, kindly see that to you, I have noted that in
So where is the
Orissa Education Act, 2U is the definition of professional courses, my lord.
So where is the order passed by the learned single judge?
My lord, that is the. My lord, order dated 7/8/2024.
Order dated?
7/8/2024. I just. Last order is that it is maybe placed before the Honorable Division Bench, and as it is a professional course.
Which order? In the first case. No, it is not that it will be placed before division bench. Considering the nature of relief, let me see. Let these matters before the Chief Justice on the administrative side. Learned single judge has not observed that it's a professional case, of course. Learned single judge is not mentioned in the order.
Assignment professional assigned to this because professional colleges matter assigned to a lordship. That's
it is not mentioned in the order.
No, that is not mentioned. Roster bench. The lordship has
Two cases. One, the IA was filed in her case.
Specially urgent matter number 1.
My lord, I just received that affidavit filed by the petitioner.
Asked me to give the option out of the 3 alternatives suggested by the BMC. And I have filed an affidavit stating that the first 2 options are not acceptable. I will take the 3rd option.
What is that?
Of waiting for kiosk to be built. And then I'll.
And in the meanwhile?
Meanwhile, I will continue. Meanwhile, my lord, I have stated.
My lord, I will have my another affidavit on this point, where my learned friend is perpetually asking for occupation till he is adjusted somewhere else. And supposing
I No, no, no. I have stated, my lord, like this, my lord.
Mr. Mahapatra, not somewhere else, there only.
No, no.
Because if you see the affidavit,
No, kiosk anywhere, it is acceptable. Your lordship says that multi-storied market complex. Can I go and start my business there? It is impractical totally. Then the second thing is ghatkia vendors. Pindi. Pindis are meant for selling of vegetables and fishes. Who will go to that ghatkia to purchase cloths, cheap clothes and other things?
Yes, Mr.
So, my lord, I have stated that if it
All right,
is...
we have given 3 options. Let us see what is your third option.
Third option they want, my lord.
Where is
They
that?
will be the para 50
Of your?
Of the affidavit filed by the petition.
No, your, where were the options?
Thank you, sir.
Options, my lord.
Option in their letter, my lord, I have annexed.
You have annexed. Affidavit on behalf of the petitioners.
Yes, ma'am. That page 10, annex 20, ma'am. That is that suggestions we proposed.
So they are accepting it.
Here, my lord, we propose one is the market subrooms available at Unit 4.
That
Near
they can't
that,
afford, yes.
that they say they can't afford. I don't know why. Then 2, my lord, we proposed the vending zone at Ghatikia. They say it is an open pindi. If lordship will go to the street vendors requirement, what they have done in practically at the particular point where they are working, constructed building, my lord. Is it street vendor, my lord? Constructing
They are
building.
ready to move out. They are not ready to remain there.
No, my lord. My proposal is they have constructed building over there.
No, this is something absurd.
No, this is not.
But for the first thrice you have commissioned.
My submission would be.
Yes.
My submission would be, lordship appoint a commission to see this spot, how they are functioning.
No,
just a minute. Permanent structure they have made.
Let us see see if there are permanent structures, the court will direct for the removal of such permanent structure. We don't have any problem with that. Let us see the options which they have exercised.
Paragraph 15 was stated till the land is required for any project.
No, where is that? We have not been able to see.
Paragraph 15 of my affidavit.
Affidavit filed on?
23(9).
23(9).
Yes.
I received it yesterday.
23(9) is not seen.
Is it a rejoinder? Your rejoinder?
No, affidavit of...
It's an affidavit.
Well, yesterday it could not have come.
Yesterday it was served to me.
We have one, 24th September. Filed on 24th September.
20, they said 23rd. I received it. We received it on 25th.
Yes. Let us see what you have stated. Yes.
Where is the offer?
Offer of BMC.
Offer is earlier the...
Offer, my lord. That is the same affidavit.
Annexed 20.
103 page.
20, my lord. Page.
There are 3 offers.
Page 10, my lord.
So 3 is 3.
Paragraph 10.
No, page 10 of my affidavit.
So option 1. Petitioners may wait for vending kiosks of BMC.
No, let us come to
in
page
nearby
10.
location. Yes, sir.
Let us come to page 10.
Yes. Lordship is how to apply for
page 12.
To
yes.
apply
Page
for
12. Page 12 it is annexed. Page 12 of the affidavit. Subrooms available at Panchadip Market Complex, 26 numbers, office space 66 numbers, Pindi available for running vending units at Ghatikia, 39
This is
numbers.
not, this is second option.
This is the first and second.
Available for running vending units at Ghatikia, 39 numbers.
So they want for whenever kiosks are in nearby location.
Because the government has already opined there is no land available.
The petitioner,
Clearly.
you have stated that the petitioners were also suggested that they may wait for the vending kiosks, a BMC which will be constructed for street vendors on availability of feasibility grant in nearby location. You have stated it.
No. That doesn't mean that you will be occupying this one.
No, they will not occupy, Mr. Mahapatra. What they say that you are offering them kiosks. They are ready to have kiosks.
Because taking into account, my lord, the earlier.
No, that they will have to come on the contract proposal. We will direct.
And I have stated, my lord, that in case the plot is required for any project of the state government and all other person occupying the same are removed, also go.
I'll come back on this point, my lord. Let it come after vacation. I'll come back.
But thrice they have promised, taken money to build the chaos.
No. Has it been refunded? You are not collecting.
Thrice they have gone back. And my friend makes any type of statement he likes.
They are marginalized people. And see, when you are saying that they have made permanent structures, they might have made permanent structures because they did not have any other thing to do. So if they did not have any other option and you allowed them to make permanent structures and then they are ready to leave there. And thirdly, if they have made permanent illegal structures, we will direct for removal of such
That's
structures.
not a problem.
But you will have to make alternative.
Let this proposal be, I'll be giving it to the corporation. We'll come back after the vacation and give the possibility of that. Then we'll after
again,
an affidavit has been filed on behalf of the petitioners to petitioners in the light of the offers which have been made by municipal corporation for allotment of shops / kiosks / spindi. Stop. The petitioners have stated in 15 as under. Stop. Learned Mr. Mahapatra, learned senior counsel appearing on behalf of the BMC has submitted that he shall seek instructions in this regard and address this court on the next date. Stop. He has submitted that permanent structures have been made by the street vendors on the road, causing serious hazard, causing
not on the road.
Roadside.
Roadside. Do you, Mr. Mohanty?
We will remove blocks. That is not a problem.
If you, this is the problem which we are suffering because we don't have any footpath. All right. And those who do not have, in fact, if you have to go for say 500 meters, you prefer car because you don't have that footpath available on which you can walk. So if the permanent structures are there on the footpath,
and if your lordship is in Cuttack, your lordship cannot go by a car.
Therefore,
this such lanes.
Therefore, Mr. Mohanty, this issue should be raised that a pedestrian has the first right on road.
I agree.
All right. So everyone, those who have cars, those who have, they can easily travel. And a person, see, children, If they want to walk on road, they cannot because the footpaths are occupied.
That's right. That there cannot be two opinions about
Yes.
this. No, that is a problem not only with this city.
This should be
everywhere.
Yes, you are right, and this aspect should be addressed. Made on and around the road, causing serious hazard to the traffic. So stop. Whereas the BMC, whereas it is open for the BMC or any other authority to take steps in accordance with law for a removal of unauthorized permanent structures, it is also their duty to look into the genuine grievances of the street vendors. So stop. List this matter on 23rd as the first case.
23rd
of
October, first case.
Interim order.
Interim order shall continue. Item
First hour.
Why?
Illness of.
Yes.
Item number 4.
Item number 4, my lord. I am filing petition for little time, four weeks time to comply your lordship's order dated 12th of this month. I have filed it yesterday.
Have you given him a copy?
Yes, I have given copy. Just 4 weeks time may be granted, my lord. It is a land scam matter. That is why I am taking time. It was investigated by the CBI on the order of the High Court. That is why I am taking little time, so that old case, my lord. 4 weeks time only I want.
So 4 weeks time for
Yes, my lord. Both the compliance, because I have to file a affidavit, my lord. That is my.
Yes.
You paid the cost?
No, I will file, pay cost and also file the affidavit.
So far as compensation is concerned, lordship
I have-
My lord, this is a matter where the entire land, his vendor, that I will,
It is because of you.
his vendor actually,
See, it is because of you. You are
Yes.
not filing affidavits in this petition.
yes, my
is
lord,
pending till then.
that I will, comprehensive affidavit I will file with the cost, my lord. That you know.
Requested on behalf
Yes.
of the petitioner. Time for an affidavit is said to have been filed.
On
On behalf
25th, I
of
have filed, he
OP?
filed.
OP? On behalf of OP number?
On behalf of OP number, it is filed by the collector, my lord.
Filed by
the
the collector
Yes, ma'am.
seeking extension of time for compliance of this court's order dated so and so. Stop. Considering the facts and circumstances and submission made by learned AGA, list this matter on. The time for compliance of the said order is extended by 4 weeks from today.
Yes, my lord, my lord.
4 weeks from today. Stop. Does this matter? Oh, week 28th of
lordship, by last order, your lordship directed to land acquisition officer.
Yes, it is collector.
Lordship, kindly have a glance. Order dated 12/9/2024.
collector.
land action officer was made as opposite party number 4, Your Lordship.
So what do you want?
Direction.
See, he is seeking extension
Yes.
for compliance of the order.
Yes.
That's all.
Yes.
That application has been filed by the collector.
Yes.
We are entertaining.
Oh, bless my Lord.
Item number 5.
Lordships would see order number 64. There was a
64.
direction, 64, dated 5/9/2020. Wherein your Lordship requested me to give suggestions for developing a portal.
Yes.
So I have given those suggestions, I have shared them with the government.
Yes, my Lord.
Yes.
There are 6 broad suggestions. And some of them would actually reduce the burden of this PI.
Right.
According to my humble submission.
And that will keep them also reminding.
Yes.
Yes, yes. That
What
is-
I have suggested is it in auto mode, like the Legal Services Authority will give their inputs regarding their visits, and the prison development can fill in their compliances in that same place, so that it remains in power. And I have suggested that all intricate details need not be given, just the basic factors. I have, in fact,
Where is your affidavit?
My suggestions are on top of the record. It says suggestions for development of portal by amicus placed on top of the
record.
Yes, yes. 25/9,
digitized.
24, my Lord. I have received
Just-
it yesterday, my Lord.
Just suggestion. It's good. So that our High Court team will also.
Lordship wants, you can give a hard copy also of that suggestion.
No, we do have.
First one is pursuant to the directions of the Supreme Court, there is a UTRC committee meeting for every district. So if some of those details, the UTRC gives recommendations, and how many of them actually are fructified, that if that can, those statistics can be given, then that would be a.
Where is that? Where are your suggestions?
On top of the record.
Suggestion for development of a portal.
Yes, yes. Regarding prison reforms.
Internal page 2, there is a chart given by my Lord, it's senior. My Lord, senior advocate.
Annexure 2.
Page 2.
Page 2 that we have seen.
Sample.
Sample, that is a sample.
No, page 2 is only for district legal service authority visits. B.
So they visit every month and submit reports.
Portal can be developed. Okay, just correct. Pursuant to.
So the first suggestion is regarding the UTRC meeting details. Those that the meetings this would help in reduction of the overcrowding wherever it happens, because these committees recommend persons to be released, premature release. So it's a committee formed by the orders of the Supreme Court.
So that can also be posted on the website.
That can also be posted.
Along with the date and then whatever
And what-
follow-up has
what's
been
the
taken.
follow-up?
That can be one thing, and then
The next one would be, the second one actually is more important, because each of these DLSs visit all the jails and they give these small problems where some kitchen is not there or toilets are not working. So those minor things, it's on auto mode. That's what I have suggested. Suppose they say that X jail doesn't have a proper CCTV. Then they put it on the website and then it's out in public domain. So there's some pressure on the government to rectify it within a quick
Accountability.
turnaround time.
My learned senior friend talking about accountability, so that it will be.
And all this doesn't have to come to the court.
In fact, the entire thing will go to the government,
Yes.
and the government will take a decision,
Yes.
and they may add
Yes.
to these suggestions.
Yes, sir.
All right. And we will direct the Legal Services Authority also to develop its own portal of prison management or something.
May I pray, Your Lordship? I had made a small note. I'm an intervener in person, and the issue was two things, my lords. One is nutrition of the jail inmates and the education of the jail inmates. My lords, unfortunately, the government has filed two affidavits, which the second last affidavit, they have not mentioned the higher category of calories, which has to be given to the laboring prisoners, my lord. So that if that could be part of the portal, maybe there'll be more accountability, as suggested by Mr. Patnaik. That the laboring people who are doing hard labor deserve a better diet, calories, as per their affidavit. And they're not been given that, nor is it a part of the jail manual, my lords. So nowadays, unfortunately, food is being used as a tool of torture, my lords.
How do you say? What is the what all are they provided?
Yes, my lord. The calories are in their affidavit only. They have said such and such details they've given, which adds to 2,800 some odd calories for the normal diet, and which should be 3,227 kilocalories for the laboring diet. According to them, they have set up a committee, and the committee came to this decision. But unfortunately, I was shocked to learn that in an affidavit filed thereafter, they've again gone back to 2,816. So, A, they're not giving it as much importance as it deserves, and B, certainly it is not part of any manual or any instructions which requires them to be accountable to.
But who will decide finally? According to
Their committee.
They had constituted a committee.
Yes, my
that
lord.
committee will decide.
That committee
No,
had
the
decided.
committee had decided. You are not following the
Well,
decision of the committee.
I will definitely look into it. If we have decided, we have to follow.
Yes.
No, you have not decided. The committee had
Committee,
decided.
yes.
So you had to take a decision on the
Yes, ma'am.
And implement it.
And what about education?
Education, they have, according to them, they have written to the directorate asking for what steps can be taken, and they are waiting for the reply. So no implementation as of now.
You cannot await. Education cannot wait for anything.
My lords, on their, in their affidavit dated 17/1/24, they had said that we've written to the department to record the details of such schemes applicable or can be provided to the children. But my lords, any case, common sense would say that certain kind of books would anyway be available, should be available prior to implementation of
We
schemes.
don't pass orders on common sense.
I understand. But they are waiting, they said. They have to pursue it with the department.
We'll see. Do you have any online mode of?
We have to make it now. This portal will have to make and come back to your lordships how the portal will be.
All right.
Your Lordship, if the portal could also talk about these two.
Yes, yes, that is what I am just.
Mishra and senior counsel appearing as amicus curiae. Stop. In the light of our observations recorded in the order dated 5/9/2024, he has placed before us his suggestions for development of a portal to address prison reforms. Stop. He has submitted that by that a portal is required to be developed in a larger public interest, on which following information can be reflected. Information should be reflected. Quote from he to give your soft copy. They're just soft copy of that.
In Word format, we would give.
Right from A to F. So stop. MS Padhi, Land Council, has filed an intervention application and has appeared in person. Stop. She had raised the issue of providing poor quality of food to the inmates of various prisons in the state of Odisha. Comma improper. Right. She has argued that the inmates should be provided
Laboring diets, my lord. It's called laboring diet for those who are
laboring diet to the prisoners who are entitled to such diet in terms of recommendations made by a committee constituted for the said purpose. Stop. She has argued that the committee had recommended how much calories?
327 K calories.
327 K calories. A diet having so and so K calories
For the laboring inmates.
for the laboring inmates, but they are in fact being provided with
2816 again K calories.
So stop. She has also submitted that the issue of imparting education to the inmates, education and training to the inmates should also be duly addressed by the state. So stop. The information regarding the quality of food, quality slash quantity of food, and the nature of education, public training should also be put in public domain through the portal.
Yes.
Comma, she suggests. Stop. Next, before we pass orders, comma, which we consider apposite in public interest, comma, we direct. You have IG presence.
My lord, yes, my lord. IG presence and other officers like home department also will be.
We direct the
government, my lord, direct the government, my lord, so that
the government of Odisha to look into the suggestions made by Mr. Mishra and senior counsel, as well as the issues which have been raised by MS Padi, comma, the intervener, as has been noted above. Stop. Let a copy of this order be communicated to the State Secretary, State Legal Services Authority, Odisha, for him to consider developing a portal of the Odisha State Legal Service Authority, displaying relevant information, so as to display the relevant information by putting the same in public domain in relation to prison administration and the welfare of the prisoners in the light of the suggestions noted here in above. So stop. We expect that the state government of Odisha shall not confine itself to the suggestions which have been made. Rather, they may, since they have more exposure and better expertise, comma, come out with a better portal than what has been suggested by the learned amicus curiae and MS Padi. List this case on after. Do something in the
Yes, my lord.
So many things have happened. So many things. The court like to know from the state government of Odisha as to whether they have any online system of teaching the prisoners. So stop. If not, whether it can be, it is viable to consider it for introducing an effective system of teaching and training the prisoners. Yes.
Is there any system of connecting all the jails online?
Yes, that it will automatically happen, my lord.
If that happens, you can invite lecturers to address online where all the inmates of the jail can avail of the
Also, health
facility.
condition also, I will suggest one. It is not there in the
Yes,
order.
yes. So whatever strikes you,
Yes,
you can
yes,
also
yes.
suggest on your own.
So
regarding
it will, when it will be connected throughout, so it will be one portal. Many things can be done through that portal, including the online teaching.
It's very easy.
They have a mechanism where through VC they are conducting evidence.
trials and all that.
They do.
But I'm
So
saying all
once
the
that
jail
is in
education.
place, they just have to modify it for teaching.
No,
With
one
all the jails
individual
together.
teaching per jail. But if all are connected, teacher teaches, everybody can avail throughout the states.
There are channels
Yes, yes.
of Doordarshan,
TV, correct.
all right, which you can have their materials for teaching class 6, class 7, class 9, class
Yes.
10, even BA, MA. So those materials are there. So that system can be
That also
easily
can be
introduced. So that can be copied, and you can think
avail
better
of
than us.
Correct, yes.
See, we are here to decide disputes,
Yes, yes.
and we cannot claim that we are efficient than you, and
Well,
we have
not that my lord.
better. You are in the field. You can think even better than us. Yes.
Obliged, my lord.
After vacation. We are grateful to you.
Same, Mr. Mishra. Round of indisposition of Mr. Mishra. 6.
Item number 7.
My lord, this matter kindly be taken up after lunch.
After
Lunch.
lunch.
Yes, my lord.
Item 7.
Why
Item
are
7.
you feeling hungry?
Prasanna Kumar. Patna. Prasanna Kumar.
Oh, ठीक है, smile.
All right.
After lunch. And after lunch,
Because we had given us last chance.
yes, right. So,
Item number 8.
Please also. Matter relates to that Sisu one. Last occasion, Lordship directed to file a detailed affidavit pursuant to the order dated 1/8/2024, and so also submitted against the report submitted by the advocate committee constituted by Lordship on 19/7/2022. They were
no. I was asked to file an affidavit. I filed it yesterday through e-filing, but I am giving the hard copies to Lordship. Lordship may kindly go through the details I have given there, Lordship.
how much time, further time will you take?
Yes, sir. If our is my affidavit, take it for the day. The paragraph 3 of that affidavit. With regard to functionalization of G+6 multi-utility building and for obtaining fire safety certificate in respect of the hospital building, it's only that the fire personnel of Kotak Fire Station inspected the building on 21/6/2024 and submitted a fire prevention safety inspection report indicating some shortfalls for grant of 1 year fire safety certificate to the hospital. Accordingly, the electric and civil works have already made this the shortfall notice by the fire personnel are in all respect. Further, it is humbly submitted that the alienation proposal of the land on the building of the Sishu Bhavan is not submitted that Board of Revenue has written a letter to the government of the Odisha a letter dated 6/8/24, and after obtaining the title deeds, now he will apply for the permission. And in that process, we have stated that by end of March 2025, the building shall become completely functional.
And OT will become installation that you written, modular OT.
OT, because now the OT in the old building is being there. I have come, also may come to the subsequent paragraphs. I have stated.
All these years it was functioning without that title deed.
No, the building is alienation proceeding has been initiated because it's interdepartmental notes. Now it has to be. Exactly. Yes, unless you have a deed, they will not give the fire safety certificate notes in favor of the institution.
So now you have started going in the reverse direction. Your building has been constructed, but you don't have the title deed.
No, that
Then
is
after you have the title deed, you have the building plan. Your building is ready, but you don't have the building
no plan has also been submitted. Unless he gets the superintendent gets the title deed in his favor, he cannot get approval of either the building plan nor the fire safety certificate.
Fire safety is now going backwards.
Yes, yes, but should have been done at the earliest. Thereafter should have building construction. But they do it and thereafter they get post facto approval of all these things.
So how much time will it take for this title deed and
now it's pending with the government. I can write to the government to complete the alienation proceeding at the earliest, so that the fire safety certificate, so also the building plan can be approved. But for the installation of all these things, OT and scan and other things, it will be by end of March 2025 for fully functional.
just let this be done? Building plan, fire safety,
Yes,
and
ma'am.
title deed. So let us confine to this.
Yes, ma'am.
You are saying battery operated vehicle will be by December 2004.
Yes, ma'am. By December, that will be done, ma'am. And all these OT and scan, all the facilities are.
No, let us confine
Yes,
presently on this this land
and plan,
then
including fire safety,
and then plan.
Yes.
So three things.
Yes.
What time?
Because you'll also grant me 2 weeks time. In the meantime, you see that alienation proceeding is over. Once it is alienated, recorded in the name of the hospital, it can be done immediately.
We are giving you 4 weeks time.
Yes, no. I will come up with the developments.
No development. Or if you want 6 weeks time. But in the meanwhile, this process must be completed.
Yes, no, sir. Yes.
Fire safety certificate, the building plan, and the title. These things must be completed.
Yes.
Later, we will see how will you progress. But these are technical things.
Yes, so that can be
And
expedited.
this is happening because of the court's intervention.
Right, no, that is true.
My Lord has rightly pointed out, after completion of the civil work, they have now taking steps for approval.
Plus, in a lighter vein, that was also the fate of this building also.
Oh, that we are in a position to overcome that.
Right.
Yeah. Yes.
6 weeks, Lordship, I will see that done in the meantime. All these
We
three.
will take up the matter tomorrow.
No,
All right.
no,
Tomorrow you can talk to them.
no. I will obtain
We
instruction.
will fix a date.
Yes.
Within that time, these things at least must be
Three
done.
things, no.
These are formalities.
Yes, yes.
The formalities must be completed.
Right.
Let him appear because he adjacent to this building.
Monday, yes, sir.
You tell us on Monday.
Yes.
We will take up. Give us specific date.
Deadline, no. I will give that.
All right. Failing which, we will direct personal appearance
Yes,
of
yes, no.
all the top officials.
Yes.
Copy make I leave Sharma.
I will give the copies. I will get the
Get a
thereof,
copy
give
of,
all copies.
An affidavit has been filed on behalf of the state in the light of this court's order dated 1/8/2024. Let a copy of the said affidavit be served on counsel for the petitioner. List this matter on Monday.
Item number 9.
This is a, but here we have prayed
Item number.
the order of
9.
compulsory retirement.
Compulsory retirement of.
A judicial officer.
So there was no provision for, where is the order?
Order is not at page 22.
Connection.
Annex 1. In pursuance of Rule 44, Orissa Superior Judicial Service and Orissa Judicial Service Rules 2007, read with first proviso to Rule 71A,
What is your date of birth?
1956.
The date of birth means not the year of birth.
Sorry. 14 July 1950. In fact, there was a first review at the age of 50.
Yes.
In first review, Millard, I was not retired. Then I was promoted.
Yes.
And Millard, this order in fact passed proviso to Rule 44, which has been stated in their counter, which I have pleaded in para 21. So if your lordship will see, Millard, kindly 44, Rule 44.
No, counter affidavit, we have to see the order.
Millard, it is only stated with regard to 44 OSJs with the first proviso to Rule 71A. of the Orissa Service Code.
Yes, proviso, it's very clear.
Yeah, Milord, proviso, Milord, yes. Milord, Milord, that is what my contention. Proviso gives the power to review it every year. Milord, the
So
first,
there are three things.
Milord?
There are three aspects.
Yes.
The first says that 3 times.
Yes. Yes.
There should be review.
Yes.
Second says, second says it should be at least 3 times. If you read 1 and 2 together.
Yes.
And then the proviso is beyond this 1 and 2.
Yes.
And it reserves the inherent power of the employer to terminate the service
after 50.
After 50 any
After
time.
50 each year. Each year there can be a review.
No. See, there are 3 things. It is not that only based on review as stipulated in sub-rule 1 and 2.
No.
One can be compulsory retired.
Yes.
In addition to that,
yes,
the state government has power,
yes,
in consultation with the High
Yes.
Court, to retire under the proviso. Proviso be read with 1 and 2.
No.
Proviso is an independent provision in this case.
That's an independent provision, and that will only comes that after the rule 50, age 50, proviso would operate.
Yes, after 50.
After 50. So that is what I say. So after 50, there would be the assessment.
Therefore, I am saying that this proviso
Yes.
is not connected with 1 and 2. The proviso is despite, or you can say in addition to,
yes,
sub-rule 1 and 2. Proviso in this case is independent provision.
Milord, it is independent. Milord, that is that what your lordship is saying is, Milord, that is the correct. But that will not override.
It overrides.
No, override means Milord 50 is there.
Yes.
55 is there.
Yes.
Then the Milord 50, then 58 is there.
Yes.
3.
Yes.
Milord 50 there is a review.
Yes.
Then Milord, the proviso is there. So a person can be again reviewed at age of 51.
Without a review. 51, there is a review.
Yes.
50, there is a review
Yes.
after completion.
Yes.
50, it is decided not to. Now, at the age of 51,
Yes.
without any review, this proviso confers power on the vests power in the employer to compulsory retire.
Accepting that they have a power. The power has to be implemented. Power has to be exercised. Then that has to be on materials. There has to be on materials. And materials, Milord, the materials where, Milord, in 50 that they have already found out that person is fit enough to continue. There is no other material. There is no fresh material. In 50 to 52, rather I have been promoted. And there is no fresh material. I have been, Milord, for which a person can be said that yes, this is the fresh material. I'll show, Milord. In one of the Delhi, Milord, which is in Supreme Court ended, they said yes, it was in 70, it was done. 70 to 71, yes, they have gone down. Therefore, again, they have found out assessed, yes, they can be chopped off. They become dead. Here, Milord, it is reverse. Reverse in the sense, Milord, I have got a promotion. And Milord, and these 2 years, I have not reduced myself.
See, there is nothing against you.
Milord, your lordship, Milord, last date, your lordship has already clear, my lord, there is no doubt about it. There is nothing against me, my lord, that this is not a stigma, nothing. My lord, what I, my lord, I am, before your lordship, I am seeking to, my lord, only, my lord, canvassing, my lord, that whether there is any material which can exercise the power. Power is there. My lord, I am not at all, my lord, I am saying, my lord, that there is no power. Proviso, there is a power, and the government cannot, it is only the High Court will say that, so that because 235, because 35 rule, the High Court is they have to recommend and it has to be accepted. That is correct. Because that is nothing. But when it has to be done, so there should be some material.
Where is the requirement?
Requirement, my lord, any decision, my lord.
Any decision, show us.
My lord, that is what, my lord, I am showing. My lord, first decision I am showing, Odisha High Court. Odisha High Court, here is a case 50 and 55. They say that 50, 55, 50, first 50, he was reviewed, he was found fit. And 55, so they said only between 55, that should be the material, so that he can be taken out. That's what I want to show. And the other one I will show from the Supreme Court, that there should be new material. These are the two decisions I will rely upon. And further, my lord, I will seek, my lord, since your lordship is so acquainted with the Tata Cellular, I did not read out. The Tata Cellular is also an administrative decision. And here, my lord, what has happened? There was a DP that was issued prior to 2006, prior to 50 years. And that DP was resulted in an exoneration. And that was held in 2008, that exoneration, prior to this order of, my lord, the compulsory retirement. But that proceeding, my lord, it has been exonerated. It ought to have been taken into consideration. That was not at all taken into consideration. Not the recommendation which has been placed before the committee to review, that they have not stated. Rather, they have given the two charges out of that. Instead, they should have said that yes, this has been already recommended, already this has been reviewed. DP has been done, in DP he has been exonerated. They did not say so. So these are the, my lord, the things, my lord, which I will place before your lordship's kind consideration. Because, my lord, that is what. So, my lord, the first, my lord, I am relying upon 2017 to OLR 628. I'll just take relevant paragraphs only, not to bother about the whole decision. Para 8 at page 632. It is averred in the writ petition and also contended.
Which paragraph?
Paragraph 8 at page 632. It is averred in writ petition and also contended by learned counsel of petitioner that as per Rule 44(2) of OSJs and OJS rules, whether any officer of service should be retired in public interest under Sub-Rule 1 of 44 shall be considered at least 3 times when he is about to attain 50, 55 years and 58 years. It is submitted that on completion of 50 years, the services of the petitioner was reviewed by the High Court in 2009. After taking into consideration his service record, the petitioner allowed to continue in service beyond the 50 years of age. It was found fit to be confirmed. The so and so and was found capable of suitable holding post during the review at the age of 50, and was found and suitable to continue further beyond the age of 50 years. Thereafter, there is no other misconduct or adverse remarks against him for which he was found fit and suitable for confirmed in so and so rank. Decision recommendation High Court in admitted side to give petitioner compulsory retirement at the age of 55 was wholly uncalled for. It is submitted that there is no additional adverse material against the character, conduct, or integrity performance of the petitioner, except those which are available already during the remote past and taken consideration for review of his service at the age of 50. The very same materials would not be said to be sufficient for the purpose of recommending the compulsory retirement of the age at the age of 55 years. This is what, the very same material. Then kindly turn to para 15 minute. Your para 15 re quoted the 99-2 Supreme Court. The relevant portion is subparat C. As your lordship was saying that this order of compulsory retirement not a punishment, it implies no stigma, no sanction, misbehavior, and the order has to be passed by government on forming opinion that in public interest to retire the government servant compulsorily. The order is passed on the subjective satisfaction. 3 Miller, the principles of natural justice have no place in the context of compulsory retirement. That doesn't mean that judicial scrutiny is excluded altogether. While the High Court or this court would examine the matter as an appellate court, they would not examine the matter as an appellate court. They may interfere if they are satisfied the order is passed a malafide, B, that is based on no evidence, and C, that it is arbitrary, in the sense that no reasonable person would form the requisite opinion on a given material. In short, if it is found to be a perverse order, then kindly Miller, your lordship turn to 24 at page.
Yes, any other decision?
Miller, I would show Miller the decision is next. 2001 Supreme Court 1109. 2001 Supreme Court 1109.
Yeah.
It is only para 11. Your lordship can take note of this. There only I am getting that 6 and 7. The order of compulsory retirement shall not be passed as a shortcut to avoid the department inquiry when the course is more desirable. If the officer was given a promotion despite the adverse entries made in the confidential record, that is a fact in favor of the officer. These are the two things I want to show. This is the reachable.
Yes.
Miller.
Yes.
This decision is your lordship has got 2011-10 SEC.
Yes, that we have seen.
Miller?
2001 we have seen. 2011.
Yes, 10 SEC page 1. Miller, I am stating Miller with regard to the relevant paragraphs are 1, 2, 3. Then para 69, 81, 82, 83, and 85 kindly similar. This is the last one I will rely. 85, page 43. Page 43. At page 44, kindly see. Page 85, para 85. Even if it is assumed, may I please?
Yes.
Even if it is assumed for sake of argument.
Paragraph 85.
85.
Yes.
Even if it is assumed for sake of argument that the principle laid down in Chandramohan Nigam case, that Chandramohan Nigam case is that is 77-4 SCC 345.
Yes.
So even if it is assumed that for sake of argument that principle laid down would apply with all vigor to the facts of appellant also. The court finds, this is important. This court finds that in respect of all three officers, after previous consideration in July 2000, new materials in form of SCR for the year 2000 C integrated doubtful and had come into existence and had become part of respective service record when the full court in its meeting that held on 13/9 recorded their SCR for the year 2000. Thus, the consideration committee constituted for the purpose of evaluating the cases of officer assistant whether they should be compulsory retired by subsequent point of time, namely on 21/9/2001, and as such, it will be fully covered by exception spelled out in Chandramohan Nigam case. So this is what, Millard, that I am relying on.
Yes.
So here there is no material and there is nothing with regard to integrity. Rather, I have been promoted. I promoted in 2008. In 2006, there was a Millard that 50 years review. And there I was found fit, so therefore I have continued. So I was now Millard, I have been taken out at the 52. So I have not deteriorated. My humble submission to your lordship is that yes, you have the power. Court has to take out the due. Court has to take out the court can make it efficient. But Millard, I have not gone down. That is what I have stated. That is what your lordship kindly considers. And all the allegations which has been taken before the committee, those are all before the 2006. And part of that is also, Millard, that was of the DP. And DP where I was exonerated.
Yes.
This is what my case is.
Yes.
Yes. So far as DP is concerned, Millers, will have to bring your lordship's kind attention to paragraph 10 of my counter affidavit, Millers. Page 124. So there it has been, Millers, I have stated.
124.
Yes, Millers.
Yes.
Yes, there it is. The petitioner was promotion to the care of civil judge as per the direct decision of the Honorable Court dated 23/2008 in OJC number 2935 of 2001.
Which paragraph you are reading?
Paragraph 10 towards the end at page, I think.
Paragraph to end. Yes.
Internal page 3 of my counter affidavit.
Yes, yes.
It starts with matter of drawal of different salary and other consumer service and final benefits were taken up after the judgment passed in OJC number 293 of 2001. The petitioner was given promotion to the care of civil judge senior as per the decision of this court dated 20th of March 2008, and the petitioner joined as senior clerk. This promotion was given only after the decision of this Honorable Court. Then paragraph 11 you will also kindly look at. That reply to the amendments made in para 8 of the petition is humbly submitted that the departmental proceeding number 4 of 2005 was initiated against the petitioner. The charges leveled against him were served on the petitioner on 16/12/2005 and his written defense was filed on 19/12/2005. The said DP was finally dropped. No, he was never in a return.
Just
okay. Dropped as per the decision of the full court dated 17/11/2008 in view of the compulsory retirement of the petitioner for service which was communicated to the petitioner. The case of the petitioner was not considered for promotion to the care of senior citizen in view of the allegations pending against him. So after the decision of the full court to take a decision regarding compulsory retirement, the disciplinary proceeding was dropped. And decision was taken by the full court on the basis of allegations previous, also the present allegations. I mean departmental team.
There is a Supreme Court decision that had gone from Patna, where the decision of compulsory retirement was interfered with by
Nandkumar.
I don't remember.
Yes, yes. Nandkumar.
That judgment is by
1 minute. But I have laid down. Yes,
Justice
Kumar,
Lodha.
I have. That is Nandkumar from state of Jharkhand.
No, Justice Lodha. The judgment is by Justice Lodha.
Justice Lodha.
Yes.
No, this is a judgment of Justice Honorable Justice Datta.
The judgment must be of 2015 or 16.
I'll-
So the Supreme Court, in that case, the division bench had interfered with the decision of the full court.
Lord, I will give out to your lordship.
So that was not appreciated by the
Lord,
Supreme
I
Court.
will, my lord, this is our duty to assist.
All right, please find out.
Yes, yes. My lord, on Monday I will definitely give.
All right.
Give me one day only. Monday I
Well, we are giving you 1 week. As
Monday
requested
I-
on behalf of the petitioner, list this matter on.
So,
And my lord, the other part which my friend has said that DP has not been, that is at 294, that DP has exonerated me. I have given in my region.
All right.
That is-
We will see.
I've also got the record.
Please,
that-
please
that
be here
should
with
be-
the records.
that-
We may have to see the records.
Yes, my lord.
No,
because
that's his
all
preserve.
my contention has to be verified on the basis
No,
of
no,
record.
we will have to take a decision based on the records.
Yes, yes.
Also.
My version is not the correct. It is only a record has to be what is stated.
Yes.
I have one reference, of course, it's of 2001, reference of State of Bihar. This is Vishwanath Prasad Singh versus State of Bihar. It's of 2001.
No,
not
that
2000.
is.
Subsequent.
see,
I will also try to find out.
You may agree or not, but that is the
My
Supreme
lord,
Court's.
the point is coming to my lord's mind. It is our duty to.
Right.
give
Just
a-
find out.
Yes.
See, the logic which is there in these judgments, this is one, but that is also a
No,
view
my lord.
that once a full court had taken decision, the division bench ought not to have. This is just see.
No, my lord, I
And
will,
just,
my lord, it's my duty to assist my lord. Whatever,
As-
your lordship,
let
you
us
may
see.
take,
Let us
that's a different issue. Because as a lawyer of this bar, my lord, our view, my lord, we must assist.
Yes, yes, yes.
proposed.
Yes.
So it is next week, my lord.
Item number 10.
Meantime, petitioner died, I want to substitute.
Whether any cause of action survives.
Yes,
Cause of action doesn't survive. Then
petitioner died.
petition number 5.
Died in the meantime in the last month. I want to.
What do you want?
To substitute.
So what is the case?
Challenging the order of service settlement that my lord.
Service settlement.
Annex 20.
If we take up the matter after some time, you may have to file more substitution petition.
No, not nice.
Not all are.
Yes, yes. Then that, and then restored. From last month, my lord. Within 1 month. That is today informed the petitioners, other petitioners. It is also assigned single judge, my lord. Service settlement, single judge assignment.
Service single settlement.
Yes, ma'am. Dismissed by the Honorable Chief Justice.
Yes.
More than 10 years.
Will it go before division bench?
Solvent settlement plots as per lordship's roster notes, it is honorable single judge.
All right.
Only OGLS and OEA are not so before it is.
That in view of the subject matter of the presented application, that is Odisha Survey Settlement and Settlement Act, the matter ought to have been listed before a learned single judge. Stop. Let it be placed before an appropriate bench after obtaining necessary orders from the Chief Justice. Yes.
Next week.
Item 11.
My lords, finding out a way revision, I'm from the opposite party, few of the opposite parties, my lords. My lords, may I pray, my lords,
I have to take instruction. Can we take it up next week, my lords?
You're for?
I'm for the petitioner.
But how can you oppose the prayer going by the name of the petitioner?
Minutes. Then I didn't follow.
Name of the petitioner.
Name of the petitioner. Gopabandhu Sahu. They are also.
How can you oppose whatever?
Last day you were not there.
No, I was.
Madam was addressing us on the last day.
No, I wasn't.
You are seeking, you seek
I'm
instruction.
appealing for few of the opposite parties. As four, I appear for 4, 5, and 6, 8, and 12. I have to take instruction because the counsel who was engaged with the case matters from the court below suffered from some brain injury. I contacted him yesterday and day before yesterday. He's not able to speak. I requested that he should give the information so that I will collect some information from the counsel because it requires proper adjudication. I take some more time.
You are appealing for 4, 5, 6, 9, 12.
9, 4. 4, 5, 6, 9, 4. Not for others. Others, some of them have died. 2 is the main party, he has died. 2 died. 4 also. Some of them.
17 also died.
17 also died.
6 opposite parties have expired.
Main party is opposite party number 2. He died.
2, 13, 17.
It relates to residential house of the opposite parties. The opposite parties, they are residing there in long since under the Jamidar. Now we have settlement and that is under challenge. Some of from these the persons those in whose favor residential house matters. This is their residential abode. Not 30 matters, few of them. Others matters, they are subsequent purchasers, and some of them matters purchased through void Shetty. This is what is the allegation. Petitioner has been substituted. Earlier substituted because the substituted petitioners have filed that the legal has filed this petition. They filed. Now they have become 1 to 5. Yes.
So, plus, just suggest us, this is 2012 matter.
I don't want to seek for more time matters. Pray matters can be taken up. We commencing matters on 3rd matter. I will take instruction. I am in the predicament matter. The counsel who was engaged the case in court below matters suffer from brain injury matters. That is what is unable to speak.
As requested on behalf of the opposite parties, does this matter? 3rd.
Item 12.
May I please, Your Worship? I am a junior assistant in the High Court Legal Services Committee. I was appointed in 2003 by the Annexer 2. In 2005, audit raised an objection that my appointment was against the austerity measure circular of the Finance Department. Thereafter, the High Court Legal Services Committee as well as the State Legal Services Authority both moved the government in the Law Department as well as the Finance Department for my regularization. several times both the authorities, High Court Legal Services Committee as well as Legal Services Authority, they recommended for regularization, justifying my appointment. And my appointment was against a sanctioned post, and I am a graduate, I am eligible to hold that post. I was appointed without any recruitment process. I applied, I made a representation.
Then forget.
And it was with the approval of the executive
Then
chairman.
forget. No other submission.
2003. And Legal Services Authority as High Court Legal Services Committee, both have
There is
several.
no question of this. This is the appointment. Can we say that the appointment was obtained fraudulently?
No.
Then why not?
Because to meet the urgent need.
Urgent need. There are so many people.
Because in
urgent need. If you make out a case that in Cuttack there was no population, people were not living, and only you were found moving in the town of Cuttack, therefore you were appointed, the matter is different.
The submission is,
sir,
it is
don't compel us to declare that.
No, it is.
We will do that.
An irregular appointment.
No question of irregular. So fraudulently obtained. You are being given a scale. You have been given a scale 3050 so and so with the usual allowance. You are appointed as this.
To the finance department query.
Where is the question of finance? We are on this.
Your Lordship may kindly see Annex 25, page 45.
We will not see anything. We will not go beyond page 14. If you want us to declare, we will.
And the Annexure 31, the rejection, says it is an irregular appointment, it cannot be regularized.
It is not an irregular appointment. This is patently illegal.
But as per Uma Devi,
all right. Therefore, we are saying that if you want, we can hold. This is completely illegal. Sorry. You decide.
Uma Devi, at this age, after serving for more than 21 years, my fate will be doomed.
Maybe you don't know whose fate. The persons who did not have any opportunity to participate even, to apply, to think.
Well, my humble submission, had it been at that time, I could have some opportunity. At this stage, when I'm in my late 40s.
Late 40s, then why? How have you continued?
No, by now.
No, how have you continued? Where is the order terminating your service?
This Annexure 31, madam, page 54. Termination. I am still continuing. I am still continuing, but I seek a regularization.
No. Sorry. If you want this, I'll do that. This is too much. This is too much. All right. Council, after some argument, seeks permission to withdraw.
Yes, madam, I am withdrawing.
Application is according to dismissal. Yes.
Item 13.
Item 13, my lords. Item 13, my lords.
Yes.
My lords, this is a review application which was filed and which has been allowed by this honorable.
Review application.
Yes, my lords. My lords, may I pray it be taken up immediately after lunch because it will take some time.
Oh, all right. All right. But why review application is not there?
No, review has been allowed.
Application has been tagged along.
Review has been allowed. All right.
Yes, sir.
Earlier it was not on merit, thereafter review application allowed, now it's for consideration by law.
Oh.
Because they said that similar benefits have been granted to others, on that ground review was
Yes,
allowed.
yes.
All right, we will see after.
Yes.
My lord, I may be pardoned, but item 21 already has become interested.
21?
21 item.
What?
Not press.
All right. And who is item number 43? 44. Every time here. Item 44 or something. Call the
43.
43 we will take up. 44 we will take up, yes. Memories.
Item 26 and 39.
Yeah.
Item 13. Item number 13.
Karan, go.
See, perhaps we thought that after this 2 p.m. matter, it will.
All right, news.
Matter fixed for 2 p.m. hearing. Item number 26.
My lord, item 26, my lord, I may be permitted to address your lordship virtually.
Yes.
I have received an instruction from the state government. My learned friend, Mr. Das, will pass it over.
Yes.
So, my lord, the government is thinking of formulating a comprehensive policy for the medicine distribution in the medical, in the hospitals and the medical campus.
Yes.
So, they say that 6 months time should be granted, may be granted, my lord.
How much?
6 months. They said the writ appeals can be disposed of by referring to this letter. If they feel aggrieved with the new policy, they may come and challenge separately. That is what I am, my lord, proposing.
No, no. Oh, this writ appeals. Just a minute. These writ appeals have been filed by them.
Filed by them, my lord. Filed by them.
So we cannot dispose them of unless they say that it may be disposed of in the light of the policy decision which you are going to take.
What I have I've gone through that. Therefore, in order to comply with the order of the honorable court, that is the instruction which has been now state has. We need a comprehensive policy to medicine on campus in absence of the private medicine shops, as abruptly stopping closing of the shops may cause temporarily dislocation. So let's record it and dispose it of saying that if we will be agreed by the any decision to be taken, then we have a right to challenge.
But till then, actually,
Till
as it appears,
they
are protecting our interests.
They have protected our interests. No, that's a single. The honorable single judge has.
Let me explain. In fact, my lord,
It has not been challenged.
Yes.
Why would we challenge? Because they have lost in the single judge before honorable single judge. They have come in writ appeal. Maybe that was a policy of 2015 by virtue of the interim orders passed by this honorable court. They have been continuing for the last 7-8 years. So, my lord, actually the
easiest thing for us would be that if you file an application that the interim orders which have been granted in their favor should be extended for 1 year. We will consider.
No, that is not
And
the.
in the mean,
No, you will
or whatever period, 6 months. See, we are testing the correctness of the order passed by the learned single judge.
Right.
We can dispose of the writ appeals if they want, like if they don't want to press, and if they have this assurance, in view of your assurance that you will not take any step, then they may withdraw the writ appeal and we can record the order, we can permit them to withdraw. If you come out with a different policy, they may challenge that or whatever the legal
And in
remedies
fact, they
are.
have back to that. If you also look to the last part,
That is what the instruction is.
Yes.
May just
Closing of the shops may cause temporary dislocation. That they have said.
Last paragraph.
Yes, last part one. Yes.
In order to comply the order of the Honorable High Court, we need a comprehensive policy for medicine distribution on campus. And in absence of the private medicine shops, as abruptly stopping closing of the shops may cause temporary dislocation. I would therefore request you to place the matter before the Honorable High Court and seek at least 6 months' time to prepare a workable and pragmatic policy.
All right.
In availability.
Mr. Acharya, just wait. We can adjourn for 6 months, but you make an application that the interim orders should be allowed to continue. See, there is an order passed by the learned single judge. We have stayed the order. We have been extending the interim order from time to time. If we adjourn it on this ground, then we will be required to again extend the interim order.
But you will it's a government order. You will
Therefore, if the government can pass an order, your law officer can file an application for extending the interim orders. On that application can be allowed. That will keep everyone's interest intact. Like they shall be in a position to assail the order later. We shall also not feel any embarrassment that we have been extending the interim order of stay at their instance because we have not been able to take up the matter. You make an application. Yes, otherwise if you want to withdraw that, we can do.
They are telling that they want to withdraw.
This way, this can also be filed by way of an affidavit so that you also can, on that basis, we can say that.
How can?
We are not compelling. It's up to them. They may file, may not file.
What Mr. Raj said, that is what is.
This is the problem.
We can dispose of on this basis. We will take up these matters on Monday.
Smile.
All right. So in the meanwhile, let there be some clarity.
Yes.
We will dispose it off.
Yes, but I was suggesting on the basis of this letter, which is the order of the government, and the Lord Advocate General has placed it.
This is not an order of the government. This is a communication to the Advocate General.
Allah, that's right.
And this letter has been directed to be placed before the Chief Justice to seek 6 months' time to prepare a workable. Why should we give them time? So it is up to them. Why 6 months? They can take more.
Because this letter because that was to be that the government in fact will not know what kind of policy they will formulate.
We are not saying anything.
Yes.
We are not saying.
Policy I can't predict what policy will come out.
You are right. You are right. You are right.
Let's call it on Monday. So
if they are satisfied with this observation or communication, your lordship may record dispose of. They are willing for this.
All right. Then we may say, Mr. Acharya and Advocate General Odisha has produced before this court a communication dated 26/9/2024, which
letter number also your lordship may record.
Commissioner Government, copies of which are in possession of London Council of London Senior Counsel / Counsel representing the appellants. Stop. London Senior Counsel London / Counsel in one voice have submitted that in such view of the matter, they may be permitted to withdraw the present writ appeals with liberty to question the correctness of any future policy, if any, which is framed by the state government. The appeals are disposed of accordingly.
can you lordship till at least the policy is taken, at least status quo as on date.
Appeal,
They have mentioned that.
that
They have themselves
The
said.
lordship quoted that letter.
But in view of the order of the.
see those the communication is there with you.
That communication, can you lordship
You do. Please, Mr. Rauthanayake, don't
That may create a
put
problem.
us to further. We don't want to
Right.
quote that. We wanted, but we don't want to quote that the body of the communication.
Right. I don't know.
in that event, let them file an affidavit on Monday or lordship call it.
Why are you
That will be better. Milord. Let them file an affidavit.
no, affidavit? Why are you very insisting? If you want to argue, then argue on merits. I'm prepared.
On the single just you try to understand, Mr. Advocate General. Learning single just order may create a difficulty.
Maybe.
We have no doubt about it.
On merits, then it's fine.
Let it be clear that we have no bona fide of this letter.
That's correct. I'm making a statement on behalf of the government. It's in the. I am not
But
now the lordship said that we are withdrawing the writ appeal. That means the order of the single judge stands. So now they will say, while they're making the policy, they will say that order of the single judge will be utilized against us. That
is our apprehension.
Therefore, if you frame any policy, you can challenge that policy.
So your lordship rightly said that let it be called on Monday. Let the learned advocate general also take
I can't file any affidavit. I can't. Why are you? Then you argue on merits. You are not satisfied with the decision for 6 months. Then you argue on merits. Argue on merits. I'm prepared on merits.
Only thing with the as soon as the government not to disturb.
Not becoming greedy. Becoming too greedy.
Any order you can follow.
Your lordship refer to that letter number and date also. I think.
In order to, it is rightly not quoted that.
There are two former advocate generals are appearing in this case.
No, this is not that. You are making statement here.
More experienced than me. Government instruction, I am bound by it.
Honorable Chief Justice was kind to say that letter not be quoted. Otherwise, it may create future embarrassment.
All right, let us, all right.
The number
Next.
is an internal communique.
Next.
Item number 39.
అవునైతే
Good that the entire batch is over.
Entire batch is
Not around कितने में how many
The list, that runs in pages. I have
about
to,
those matters stand disposed of, they refer
all the,
Can it be disposed of by the occasional sales?
Dispose.
39.
13 minutes. I got stuck in the.
All right. We will take up next week.
Oblige.
May I please, Your Lordship?
Item 39.
Here the impugned order is at annexure 23. The
Lordships, interim order may continue an item. Next. The Lordship said next week, Monday, interim orders will continue.
Third.
Oblige.
Next Thursday.
may I please, Your Lordship?
Interim order.
Yet in this repeated this matter previously, and this whole issue involved in this writ petition, that we are challenging the order passed by the sub-collector in AP, where the opposite part number 5, though he was selected in respect of 2 Sairats, he was declared as the highest bidder, but he had submitted 1 solvency only. That is 40 lakhs. Though
Why was the matter adjourned on the transfer?
that the matter was adjourned for filing of the affidavit with the translated copy of the advertisement. That I have already filed that in the previous date. That affidavit I have filed on
Where is that? Affidavit.
23/9.
Further affidavit filed.
That 23/9/2024.
Is it further affidavit filed?
Yes, ma'am. Let the memo supported by the translated copy of the advertisement under which these Sairats were put to auction. (16/12/2019).
Yes, please
That
continue.
inviting tender in respect of 3 Sairats. That the first is that 1 Sairat is Sangagua and 1 is Sabara and Balitota. In pursuant to advertisement, the petitioner and the opposite part number 5 participated in the auction process, and the opposite part number 5, I was the applicant for Sabara sandbag. I have given a short date chart for your lordship's convenient appreciation.
Yes.
On previous date, I had given that date chart. And fixing the additional charge, minimum additional charge, your lordship kindly see for a moment my date chart. I have given everything. That the January. No, that is January 2000. Short note with date chart. That the advertisement was made on 16/12/2019,
17/12/2019, my lord, corrigendum was issued fixing the minimum additional charge, that is in respect of Balitola, ₹9, and Sabara sandbag 15, and Sangagwa sandbag ₹10, my lord. On that basis, the petitioner and opposite part number 5 along with other applicants were participated in the tender, and the petitioner quoted the 186, petitioner quoted 159.
Oh, stylus. Stylus. Oh. Yes.
The petitioner, in respect of Sabara sandbag, he was the applicant, the present petitioner. And opposite part number 5 was the applicant for Sabara sandbag and Sangagua sandbag in respect of 2 Sairats. And on the date of opening of the bid, it is found that petitioner has quoted 155 as the minimum additional charge in respect of Sabara sandbag.
Yes.
And the opposite part number 5 had quoted 186 in respect of Sabara sandbag, and in respect of that Sangagua sandbag, he had quoted 169 as the minimum additional charge. So therefore, he was the highest bidder in respect of 2 Sairats. There was Sabara sandbag and Sangagua sandbag. Therefore, he was required to pay the solvency of ₹67,79,974.
Yes.
But he had only submitted and 1 solvency, and that was used in respect of 2 Sairats.
Yes.
Pointed out some irregularity in deposit of earnest money.
Earnest money. Also, there is a irregularity. He had required to.
But did the opposite parties point that out?
Opposite party?
Yes. Regarding the earnest money.
Earnest money, he had not said anything.
All right.
So therefore, 5,72,899, he was required to deposit the earnest money. And the solvency, he was required to deposit 67,79,000.
No, earnest money is not an issue. Let us stick to solvency
Yes,
only.
we are confined to that. But when the bid was opened, so therefore, the Tahsildar, what the Tahsildar had done, he declared him and finalized the bid in respect of Sabara and Query in favor of the opposite part number 5. Because he was quoted the highest minimum charge in respect of that sand. That was objected to by the petitioner. And when the petitioner objected to that, the petitioner filed a writ petition before this honorable court as well as filed the objection challenging such selection before the Tahsildar. But the Tahsildar, after going through these irregularities, he cancelled that bid and declared the petitioner as he was the next, the second highest additional charge was quoted by the petitioner. So therefore, he was asked to meet the charge which has been quoted by the petitioner. Accordingly, he agreed to quote that price.
Party?
Opposite part number 5. What is the charge quoted by the opposite part number 5?
You were asked to meet that.
Yes. I met that, and accordingly, the environment clearance was given. The pollution clearance, everything that formality was over, and the bid was finalized in his favor. But in the meantime, he filed an appeal without impleading me as party in that appeal, challenging the decision of the Tahsildar. But in that appeal was allowed and the decision of the Tahsildar was set aside, and he was directed that the bid should be finalized in his favor. Now that order was challenged before this honorable court by me by filing a writ petition. So therefore, in this process, 3 writ petitions were before this honorable court. And this honorable court disposed of 3 writ petitions and giving me opportunity to appear before the appellate authority, and the appellate authority, after giving me opportunity of hearing, again passed the final order. But that order was passed under Annexure 23, that is the subject matter of challenge before this honorable court.
You have stated you filed in your date chart, you stated you filed writ petition 15847.
Yes, my lord.
What happened to the writ petition?
That both 3 writ petitions were pending. 3 writ petitions were disposed of together.
When?
That was disposed of by order of this honorable court.
19/1/2021.
Yes, my lord. 19/1/2021. That giving me opportunity, that order was set aside, and the matter was remitted back again to the sub-collector for re-hearing, giving me opportunity of a hearing in that matter, because in the meantime I was selected. On the Tahsildar, the sub-collector again allowed the appeal in Annexure 23 by saying that since there was no filing, the submission of 2 solvency is not necessary, so therefore he declared that his bid was not confirmed. Against that, we preferred this writ petition. And this honorable court, the government filed a counter. Thereafter, this honorable court, by order dated Let your lordship can see the order dated 21/6/2021. In course of hearing, this honorable court directed the state government to file the counter, to file the affidavit, clarify whether he had withdrawn one of his bid in respect of one of the Sairat, or whether he has a solvency certificate, only he has submitted 40 lakhs of solvency certificate. The order is like this. The 21/6/2021, your lordship got it.
Yes,
order number 3. It appears this matter is taken up by there are 2 sand Sairat queries in question in the present case. One is a Savara sand query and the other is Gagua sand query. It appears that the appellate order was passed, opposite part number 5 was still pursuing the award of both sand Sairats. And today, for the first time, the court is informed by Mr. Dalai that opposite part number 5 has given up one of the above sand Sairats, although he was not clear which one. The central point of challenge in the present writ petition is that having bid for 2 sand Sairats, opposite part number 5 ought to have given a solvency certificate which is equivalent to the value calculated for both sand Sairats. The calculation has been set out in page 10 of the petition. The court directs opposite part number 1 to 4 to inform the court what the correct factual position is, and in particular, whether opposite part number 5 has in fact given up one of the sand Sairats, and if so, which one. Further, they will confirm if the calculation of the amounts for which the solvency certificate had to be furnished as set out in paragraph 10 of the writ petition is correct. Now, these are the direction from this honorable court to be complied by the state government.
So what has happened to Sanguga sand query? That is also lying like that?
That Sangagwa sand query, he was also the highest bidder.
I know. What has happened to that?
But he had not surrendered. He had in respect of one side.
The Tahsildar has chosen the Sabara in favor of the opposite
What
partner
has
five.
happened to Sangaga? Because he has not given that up also. So is it lying like
No,
that? It has been
was
re-auctioned.
this option open to him?
My lord, no.
What happened
That
to
is the
that?
question.
Sangagwa is settled in favor of the lowest bidder, second lowest bidder.
So that has.
My lord.
Okay.
The state government filed the counter because that was not clear Again, this Honorable Court, by order dated, my Lord, just 2020. On that date, again, it was clarified. Counter affidavit has been filed on behalf of the opposite party number 3, but we find that the question posed by this court by order dated 21/6/2021 have not been specifically answered. We therefore find it expedient to direct opposite party number 1 to 4 to inform the court whether opposite party number 5 has in fact given up one of the sans serifs, and if so, which one? And OP number 1 to 4 will confirm if the calculation of the amount for which the solvency certificate had to be furnished as set out in paragraph 9 of the writ application is correct. So therefore, in view of this order passed by this Honorable Court, my Lord, they filed an additional affidavit. By clarifying the position, your Lordship can see the additional affidavit at page 158 of the brief. Yes. That the relevant portion at 159, last paragraph. It may be noted that the opposite party number 5 has never withdrawn his bid.
Just one moment, 159.
Yes, ma'am. Running page 159.
Okay.
Additional affidavit dated 23/8/2021. The Lordship can see that relevant portion at page 159. Last paragraph. It may be that the opposite party number 5 has never withdrawn his bid either in respect of Sabra Sandpuri or Sangagua Sandpuri before opening of the bid, that is 9/1/2020, or after opening of the bid, even if he has submitted one solvency certificate of rupees 40 lakhs instead of 67,79,974, as required under provisions of Rule 27(4) of Odisha Minor Mineral Concession Rules 2016. On the other hand, the opposite party number 5 has not submitted any letter to the Tahsildar Bonai to retain any of his bid out of 2 bids submitted by him. The then Tahsildar Bonai, without rejecting both the bids of opposite party number 5, Suomoto had given up one sans serif, namely Sabra Sandpuri, in favor of the opposite party number 5. This is the stand of the government in their additional affidavit. Now coming to the impugned order, your Lordship can see in what way the additional the sub-collector has dealt with. Yes. Let the impugned order at page 140, Annexure 23.
Yes.
Jaldi जाओ.
Let the relevant portion of the order let at page 143. Let's got it. 143.
Yes.
However, considering the rival contention of both the parties and perusal of the LCR, the sole dispute to be decided by this court is whether the competent authority has validly cancelled the selection of the appellant as the highest bidder via his office order dated 12/2/2020. That the competent authority is the Tahsildar. It is seen from the case record that the appellant had quoted the highest additional charge and having fulfilled other essential requisites had been selected as the highest bidder, and accordingly, Form F was issued by letter number 109 dated 16/1/2020 by the competent authority. Such selection of the appellant as the highest bidder was not questioned before the appellate court by any of the unsuccessful applicants in respect of Sabra Sandbag. This court also finds no illegality in declaring the appellant as the highest bidder in respect of the said source by the competent authority. On specific query by this court, the advocate for the respondent number 2 categorically stated that no appeal is preferred by the respondent number 2 challenging the selection of the appellant as the highest bidder. This court also finds the respondent number 2 was the second highest unsuccessful applicant in the said tender bid, Sabra Sandbag. On 28/1/2020, the unsuccessful applicant, that is respondent number 2, filed a petition before the competent authority alleging that there was illegality in the selection process as the appellant was selected having furnished one solvency certificate for 2 bids, and second, the applicant was illegally lifting sand from Sabra Sandbag. If the version of the respondent number 2 is taken into consideration, so far as the selection of the appellant is concerned, then it is not understood why the respondent number 2 filed a petition before the competent authority for consideration instead of filing an appeal in proper forum. Now, this is the consideration by the appellate authority. Proper forum challenging the selection process made by the competent authority. The competent authority, Tahsildar Bonai, rightly did not take such allegation into consideration because it would be review of his own order, which is not permissible in law. So it can be safely concluded that there was no grievance by any of the unsuccessful applicants in the selection process. The submission of respondent number 2 regarding use of one solvency certificate in more than one tender is illegal, does not hold good. All
Yes,
the,
the sum and substance of your submission is
yes, ma'am.
that he had applied against 2 queries.
2 queries.
And he had not fulfilled the requirement in terms of depositing the earnest money under Rule 2743 and solvency under Rule 2744. That is the only thing.
4. Yeah, that is the only thing.
Let
That
us
is
say
the only thing. So far as the deposit of the solvency is concerned, Miller, we are saying, and the government has also accepted, and there is also a judgment of this honorable court, Miller, that the solvency is to be calculated. And that is also the provision under Rule 2744, Miller.
Yes, yes.
That the solvency is to be calculated according to the formula.
Yes, that,
yes, Miller, I have given, Miller.
Yes.
That is the earnest money, that is the price quoted plus the minimum additional charge and calculation. Let your lordship kindly see page 10.
Yes.
At page 9, sorry.
No, what are you reading?
How the method of calculation under Rule 27(4).
Rule 20, we can read Rule 27.
I'm reading the writ petition, I'm referring to writ petition. Page 9.
Instead of referring to writ petition, we can see the rule.
Yes, ma'am. That Rule 27, 4, sub-rule 4.
Yes.
Yes. The area of the correlate shall be delineated and a notification inviting applications.
Just a minute. Rule 27.
Rule 27(4), sub-rule 4. The data is the 2016.
4 Roman 4.
Roman 4.
Income tax return, it says.
Rule 20, that must be the.
No, that has been amended, subsequent manner. Old is solvency.
The Odisha Minor Mineral Concession Rules
Amendment
2016.
Saved again.
The advertisement has been made on the basis of this rule.
No. When was the advertisement issued?
Advertisement was issued
21.
16/12/2019.
All right.
27/4/4.
Yes, ma'am. 27/4/4.
Yes.
Subject to other provisions of this rule for settlement of quarry lease, the intending applicant may apply to the competent authority in a sealed cover for grant of quarry lease for such area or areas in form M in triplicate accompanied by the following documents and particulars, namely.
Calculation is not there in 27/4/4.
4/4. A solvency certificate or bank guarantee valid for a period of 18 months for an amount not less than the amount of additional charge and the royalty payable for the minimum guaranteed quantity for 1 whole year and a list of immovable properties from the revenue authority. So therefore, the calculation
The additional charges
additional charge is
169
that 169.
or 186.
186.
186.
He had offered 186.
Sabara 186. Plus 35 is the
Well,
royalty.
that page 10. 169 quoted by the opposite part number 5 as additional charge. 35 is the royalty.
Mr. Sahu?
Yes,
Then
ma'am.
you have given wrong information in date chart. Sangaga is 169, Sabara is 186.
Yes, my lord. Sabara is 186.
Then why are you referring to 169?
No, I am referring Sangaga.
Yes.
186. The 186 is Sabara, my lord, not Sangaga.
Yeah, you are saying the total that we are
Total.
referring to both. All
So
right.
that. Let this Sabara, I have given the total calculation. What should be the total calculation? And Sabara, in respect of Sabara, my lord, 186.
Yes.
I am taking for example Sabara, my lord.
Yes. No,
186.
What is the calculation for
Yes, ma'am.
solvency certificate under section 27/4/4?
Yes, my lord.
So does
Under
it lay
section
down any
27.
formula? It is mentioned. It is there. All right. All right.
Lord, these calculation which I am referring, my lord,
All right.
that has been upheld by this honorable court. In a-
Held, if the rules provide, then we
Yes,
have to
ma'am.
follow.
Yes,
Where is the
yes,
question of any
Yes, ma'am.
judgment on that?
Yes, my lord, absolutely. Lord, 186 quoted by opposite part number 5 additional charge. The royalty is 35.
Yes, we got that.
Yes, ma'am. 186 plus 35 into the total extent of total minimum extraction, my lord, what has been provided in the advertisement quantity. So therefore, one is coming 34,87,822 and another is coming 32,92,100.
Simple. Let him argue.
And he has never surrendered. And he was referring to a judge, reporting to a letter, my lord, that it is my surrender letter. And that is totally misconceived. That is not a surrender letter. And he was referring from that letter I am just bringing to your lordship's notice.
So let him argue that point.
Yes. And in addition to that, my lord,
Yes.
But the state is supporting to their contention. So Lordship, I have my independent argument. Lordship, only to, before answering to my Lord and Senior's Lordship argument,
Two facts I want to bring to Lordship kind notice. Last occasion, my Honorable Justice Rato asked a pertinent question whether this source is operative or not, Lordship.
Whether
This source is operative or not, since because the source of 2019 till date whether it is in operation or not, Lordship. But Lordship kindly come to straight out to my date chart and I have the copies. The petitioner has already executed the agreements and that was in operation. Lordship kindly come to my date chart, that is my date chart at
Petitioner,
Lordship.
petitioner has executed agreement.
Lordship, myself, Lordship, OP number 5.
Yes,
OP number 5.
yes.
That is since
See, Mr. Dalai, you have the habit of challenging an action. Now here you are defending.
Lordship, that is all difficult with me, Lordship. Lordship, yes, but
All right.
Lordship, but I can convince Lordship because it's a difficult task, but then also I can convince Lordship. Lordship, straight I come to running
If it is difficult for you, then it is really difficult, Mr. Dalai.
No, Lordship, I can Lordship, can you come to page 178 and given the death chart, 178.
Yes.
That is on since 1/6/2022 and also given in Lordship affidavit form. Since 1/6/2022, I have already executed agreement and I was in operation, Lordship. I was lifting mines and Lordship, now Lordship, in a compelling situation, Lordship, kindly come to page 167 for a moment. 167.
Where 178, where is
178, Lordship, dead chart.
Date chart 178.
Lordship, I have in my regional Lordship, I have given the entire date chart. I have given the date Lordship that is since 1/7/28.
Let us find the date chart where it is.
Lordship, that is, it starts from Lordship.
If you are the opposite party, how did you file rejoinder?
Lordship, sorry, Lordship, that is my counter, Lordship, sorry. That is my counter, Lordship, sorry. Counter, Lordship, sorry, extremely sorry, Lordship. It starts from 168, Lordship, and the
Counter affidavit, all right.
178 is the Lordship, the concluded part of the death chart, that is, I have given a detailed death chart, Lordship, and I have given the entire sequence of events, Lordship. Because the facts is not properly.
Your date
Lordship.
chart starts at some before that. So in your affidavit, you have given a date chart.
Lordship, in the counter affidavit, Lordship, it starts from 175 date chart, 70. Running page 170, Lordship, for the court's record, Lordship, 170. And then I am just pointing, Lordship, last date, 1/6/22. That is, on that day, I had executed agreement. Then, Lordship, kindly come to, I was operating. Lordship, kindly come to page 167 for a moment.
Yes.
So while I was operating, in fact, Lordship, in this case, there is no interim order. But by a communication of the government office, Lordship.
Just a minute. In your date chart, you say agreement was executed on 1/6/2022.
22, Lordship.
Did you have the relevant purpose
Yes,
to
Lordship.
carry out?
Yes, Lordship. I was executing and I have performed, Lordship. Last 6 months I was performing.
Where have you stated you were executing?
Lordship, I have given this. Lordship, I have given the also agreement also, Lordship. And
Agreement is fine.
Lordship.
That you are operating the sand
Lordship,
quarry
can you come to page 167? It will suffice, Lordship. 167. That is their admission.
Yes.
That's 167. It is a communication to me, Lordship, from the Tahsildar himself.
Yes.
Lordship, can the subject, Lordship, that regarding the direction to stop the mining operation over Sabar sand bed. Then refer.
Can you formulate your points?
Lordship.
The argument which he has made.
Lordship.
That those are factually correct.
Lordship.
And you cannot dispute that. So you agree. Then what you submit?
No, Lordship. That I can convince, Lordship.
No, that is convinced.
Yes, but Lordship, because last second my Lord asked a query, Lordship, they said, Lordship, there is no operation. That's some convinced, Lordship. I was in operation, and after 6 months, because the Commonwealth State Council, that has been stopped.
All right.
Lordship, and I have already agreement. Not order, Lordship, because the communication of the government office, not order. There is no court order, Lordship. The court has never restrained anybody, but government council has given a direction to stop, and that has been stopped, Lordship. Then, Lordship, kindly come to the Lordship, and the second point, Lordship, because in the rules itself, there is provision of Rule 27 speaks of, Lordship. If the action process is over, the Tahsildar has no power.
That, Mr. Let us don't go into that. The question is
Lordship.
that you had applied against for two queries.
Two queries, Lordship.
You did not fulfill the requirements for depositing the earnest money separately in respect of two queries.
Lordship.
So if this fact is admitted, then what is left?
Lordship, can you come to then, Lordship, their allegation, paragraph 1. They have given the figure. Lordship, come to the paragraph 1. They have given a figure, Lordship, the writ application.
Print.
In para 1 of the writ application, Lordship, they are saying, stating two things, Lordship. As they are saying, the EMD deposited by the petitioner was not set up to the condition of the contract, Lordship, and subsequently solvent certificate also not, Lordship, up to the condition of the contract. And Lordship, they have given figures, Lordship, at para.
All right, you just tell us.
Lordship.
Forget everything.
Lordship.
You had applied against for two.
Two, Lordship.
You just let us know on the basis of whatever material you're pleading, any document that you had separately deposited the earnest money for the two or not.
Lordship, so far the earnest money is concerned, Lordship, straight out of the government counter. Government counter, Lordship, turning page. Then next part, Lordship, I can convince. Page 151, Lordship. So for the EMD, they have replied, I have deposited as per the terms of the contract, Lordship.
See, that will not do. They just saying that you deposited in terms of the contract. That is not enough. Whether they have stated that for this you deposited this and for this you deposited this.
Lordship,
Very simple thing.
They have given the figure, Lordship.
Yes.
Page 151, Lordship, can listen. Page 151.
Yes.
Lordship, C, 151, C, Lordship.
Yes.
That in reply to the paragraph number 8 of the writ petition, it is humbly submitted that the competent authority cum Tahsildar Banai has a rightly calculated amount of EMD of Savara's query as per Rule 27 of Odisha Minor Council Rule 2016.
No, where is question of Sabra?
Both, Lordship, both.
Both. Did you make separate?
Not
this
required,
thing?
Lordship.
Where is the question of not required?
As per rules, Lordship, that is not required. I can convince you, Lordship.
What?
Because, Lordship, there, Lordship, can you come to Rule 27?
Yes.
Lordship, please, 27, Lordship.
So had you applied for both?
Both.
No, had you applied for one?
Lordship.
Giving
both are independent, Lordship, auction process. It is not.
Therefore, because both are independent auction processes,
Lordship.
Therefore you had to comply with the requirement of both independently. So if you apply for both and fulfill the requirement in respect of one, then both of them are required to be rejected. It is not that they will select.
No, Lordship, grateful. I'll convince Lordship. Lordship,
Yes.
kindly sit for a moment, Lordship. Lordship, kindly, just I'm convinced, then I'll come to the provision, Lordship.
yes, calculation.
There are, Lordship, that I have, Lordship, Lordship, so far EMD as concerned, Lordship.
Okay. Again, huh? Old one. Yes.
So, Lordship, so far the EMD is concerned, Lordship. Now they have, Lordship, back out from that contention. Now they're saying we will not go for EMD. Only they're saying, Lordship, they are now disputing my solvency is concerned. Now, Lordship, so far the EMD is concerned, they have already back out and they have forgot their contention. They are saying no EMD.
Okay, stick to solvency. Yes.
Now, Lordship, solvency.
Yes.
Lordship, can you come to Rule 27? 27, Lordship,
So
there are.
according to you, there is no dispute about EMD.
They are saying, Lordship.
All right. just
Yes,
a
Lordship.
minute.
Yes, they have admitted.
Should we proceed on this point?
Lordship.
That as on now,
Lordship.
there is no dispute as regards EMD. Now we have to see whether your solvency was in accordance with the rule or not.
Rule or
Let
not.
us see.
Lordship. Lordship, can you come to Rule 27?
4.
Lordship, 27(4), Lordship.
Yes.
For the requirement of law, Lordship, 27(4).
Yes.
Subject to other provisions of these rules, for settlement of query lease, the intending applicant may apply to the competent authority in a sealed cover for grant of query lease for the area or areas lordship. In Form M in triplicate accompanied by following documents and particulars, namely. So, lordship, this paragraph just lordship conveyed my understanding, lordship. There is no lordship bar to participate in various contracts, lordship, various auction process which is protected by the authorities. So, I can participate in area and areas, lordship. Then, lordship, kindly come to requirement of law. What lordship 1. Treasury challenge showing deposit 1,000 rupees refundable towards the application fees. That lordship I have given. An affidavit stating that no mining due payable under the Act.
So these are immaterial. Come to 4.
4 lordship. In a solvency certificate bank guarantee validity for a period of 18 months for an amount not less than the amount of additional charge offered and the royalty payable for the minimum guaranteed quantity for 1 whole year and the list of immobile properties from the revenue authority. This is the independent requirement of that particular action, lordship.
So give us the calculation.
Lordship, I have given the calculation.
Yes.
Lordship, first of all, I want to convince the lordship on their contention. I am admitting their contention at this stage, lordship. As per their contention, the requirement is, lordship, for lot 1 for the first 30 lakhs, lordship. And second one, that's in 33 lakhs, lordship. So I have the solvent certificate of 40 lakhs. And I have participated independently in both the swearers, lordship, and satisfying both the solvency requirements under law, lordship. As per their contention, if they are saying that because solvent certificate is 1, lordship, because I have to give the entire my property and my lordship solvent, how I am solvent. So I have given used one solvent certificate in both the process, lordship, and in both as per their calculation, not my their calculation, lordship, both the calculation, I am satisfying both the requirements, lordship. In first, lordship, 32 lakhs.
If suppose there are 10 queries are settled in your favor,
lordship,
and you are required to solvency certificate of 1 only.
1, lordship. Lordship, then lordship kindly come to rule 7.
That this is your submission.
Let's come to rule 7, lordship. That is that.
No, we want it clear.
We want
that is your submission.
To be clear. We want to be clear on law.
Lordship.
That if you are declared H1,
lordship,
in respect of 10 queries, you are required to submit a solvency certificate in respect of only 1.
No, lordship. That is nothing my contention.
The
I can only my contention, lordship. I can participate using the same solvency certificate, having qualified at the terms of contract in different contracts.
Yes.
But then lordship, rule 7 comes to my rescue. If let's say I continue to let's come to 7, lordship. Rule 7, lordship. Rule 7, lordship. Rule 7. Lordship, got rule 7.
Yes.
Within 15 days of such intimation, the selected bidder shall be required to convey his acceptance of the terms and conditions and to deposit an amount which shall be calculated in such a way that it shall be equivalent to 1/4 of the total amount of royalty, additional charge of the amount contribution payable to the District Mineral Foundation on the annual minimum guaranteed quantity, taken together reduced by the amount, earnest money which along with the earnest money shall be held as interest with secure deposit. So, rule 7, lordship, gives me an whether I will accept the other bid. If I will accept, lordship, more than my bid capacity, lordship, then my entire bid will be cancelled. So, lordship, they have, lordship, to convey, lordship, to substantiate my arguments.
Yes.
Lordship, kindly come to the form. They have, that is it. That is form F, form F, lordship. Declaring highest bid, lordship. This is the format intimation, lordship. They are required to intimate to me, lordship, after being qualified, being declared me the highest bidder.
Yes.
Form F, lordship, reading, lordship, you are direct, lordship, perhaps third paragraph, lordship, perhaps I am not holding the same book. Lordship, that is, you are directed, lordship, lordship. You are directed to convey your acceptance
to the page.
Lordship. Perhaps I'm holding
which is that annexure? Are you talking
Form F, lordship? Form F.
All right, the format.
Form F, that is this is the communication
intimation to successful
bidder, lordship.
Yes.
You are direct. I'm reading, lordship. Perhaps your lordship, that is third paragraph. You are directed. You are directed to convey your acceptance to the terms and conditions and to deposit an amount as prescribed under Rule 10-12 and 13/1610 and 11/27/7 and 9 strike up whichever is not applicable. Proof of deposit of apportioned amount along with access should reach the undersigned within 15 days of the day of issue of this letter. Failing which this intimation shall stand automatically revoked without any further notice, and the earnest matter shall be stand forfeited. Lordship, punishment is prescribed for Lordship. If Lordship, I have participated in Lordship more than one Lordship, but I have to comply Rule 27(7). So there is a Lordship option left to me whether I will accept or not.
No.
So if I will not accept,
Mr. Seven stage will not come.
Lordship.
7 will come later. 7 C 4
Lordship.
4 stipulates
Lordship.
that the intending applicant may apply to the competent authority in a sealed cover.
Lordship.
For grant of query lease.
Lordship.
For such area or areas. In Form M.
Lordship.
This 4 also is there.
Lordship.
Let us see Form M.
Form M, Lordship. Form M, Lordship. Lordship, Form M 27 for Form M, Lordship. Let's go back.
Yes, please.
Clause 3, Lordship, speaks of Lordship requirement of the documents, Lordship. The required particulars are given below, Lordship, that is Form 3. An affidavit stating that no mining under this act and rules made thereon.
Where is that? Which page?
Where?
Lordship, Form M, Lordship, that is Form M.
Which page? Which page?
Lordship. I'll come with
All
Lordship.
right.
Lordship. That is Lordship.
We will find out. We will find out.
Lordship, I'm holding to Lordship.
Yes.
We will find out.
Lordship, Form M.
Yes, it is there.
Lordship.
No, it is not there.
It could be page 90.
Lordship,
Page 92 just.
No,
because I'm
slightly nearby.
27.
Yes, it is there.
Yes.
Form M, Lordship, page 93, Lordship. Lordship.
So, if you apply
Lordship.
two queries, you will have to apply two Form M.
Lordship. Grateful, Lordship.
All right.
Grateful, Lordship.
So, whether you file or not.
I already filed two forms, separate forms.
Two
Lordship.
forms, the same solvency
Yes,
certificate?
because Lordship.
Yes, yes.
Lordship.
One solvency will be given if you have one
Because I have
property.
one- That is Lordship, the solvency is one, Lordship, because
All right.
it my.
Yes, yes.
That's my property.
Yes.
So if Lordship can give us a second page, so there is an indication that I may be participating number of Lordship sources and Lordship working in hand, that also I have to disclose. Everything is there, Lordship, Form M.
Yes.
So there is no rejection so far my Form F M is concerned, Lordship.
Yes.
They have accepted, Lordship.
All right.
And subsequently they have traveled one step ahead and they have declared me highest bidder in both the bid. And after declaring me highest bidder, Lordship, can see what they did. Immediately they wrote to me, because on 16, Lordship, on 16/1, Lordship, that is, they declared me as the highest bidder. The 16/1/2020, and Lordship, on the same date, they have wrote letter to me in both for both the bids, Lordship. That is at running page 77 and 78. Sorry, Lordship, 161 and 162. 162, Lordship.
Yes.
Lordship, can come to page 161 and 162 on the same date, Lordship.
Yes.
After declaring me highest bidder, Lordship, I'm reading page 161. That is on 61 to 20. This is letter of Tahsildar. This is intimate that you have quoted highest bid additional charge of Sanagagua, but after scrutiny, it is found that solvent certificate of rupees 40 lakhs, only which is attached to the tender Sanagagua, is also attached in the tender application of Sobara bed, in which you are the highest bidder. Therefore, you are directed to submit the new solvent certificate, that is bank guarantee of rupees such and such, only to undersign within 7 days and failing with the tender application will be rejected. Then Lordship kindly come to
Yes.
Lordship. The intimated me Lordship on page 161. Then Lordship page 162. So far the second with Sabaraj concern Lordship, they declared me here also highest bidder. And Lordship kindly come to page 163, my reply on 22(1) and 20. In consonance rules, Lordship, here Lordship I denied not to participate so far the Sanagagwa is concerned. I am not unable to. Lordship kindly see my page 163.
Yes.
With reference to the letter on the subject side above, I am unable to submit bank guarantee of rupees 32 lakhs for Sanagagwa sand body due to my financial problem. So I have no any objection in the highest bidder shall be rejected in my favor as the advertisement, the earnest money such and such, and I have given.
So had you complied with this 2743?
Lordship, 27 Lordship.
2743?
3 Lordship, I have complied Lordship. That is more than amount Lordship. That is 1 lakh. I have given 1,50,000 of 70,000 of bank Lordship EMD, but Lordship within 10,000 Lordship. That is the
because 1 year.
Lordship. That is a wrong calculation made by them, which is supported by the state government.
What will be the solvency for 1 year?
Solvency Lordship, if we take it their calculation, both the bids Lordship, it is less than 40 lakhs.
So give us the calculation.
Calculation I have given Lordship. My calculation Lordship, kindly say my counter they have not replied. My calculation Lordship.
Give us the calculation. Where is the calculation? You tell us.
Lordship, kindly come to Lordship. I will give. Lordship, kindly come to page 189.
Yes.
They have not replied to this Lordship. I have given a calculation. I have given a figure. Lordship, because last time making another point, Lordship, this is as per the, so that's why Lordship I have given the figure, Lordship, a translation copies and a series of documents.
Where is the question of denials in such case? It must be governed, there must be some rule.
Lordship, rules as per rule, Lordship, kindly come to one thing I can demonstrate before Lordship. Because I have given translation copy, Lordship, kindly come to my annexer A by P3.
So you have given yourself 39.
Lordship.
39 lakhs or 39,000.
39,000 Lordship, that is 849.
39,000.
849.
So it will be 76.
Even if they are saying 32 lakhs, I also don't have any complaint. 32 lakhs also I am qualifying Lordship. Because I have given 40 lakhs of. My requirement is Lordship 32 lakhs. If they are saying one is 32 and other is 34 lakhs, but I have given 40 lakhs of solvency.
No, but you have given for both. So if their contention is accepted, you have to select one only.
Because it cannot be Lordship, because they are independent sources.
Yes.
And independent applications are there, Lordship.
Yes.
I have given different application shield cover.
Yes.
So Lordship, both all the applications cannot be Lordship evaluated in total Lordship. So individually decision has to be taken by the competent authority. So a decision has been taken by the competent individually, and they have qualified me. And so far, the second bid is concerned, Lordship, while issuing me notice under Rule 27(7), Lordship, I have refused. No, I can't give I don't have the capacity. So Lordship, I have followed the requirement of law, Lordship.
Submitted two forms.
Two separate shield covers, Lordship.
In respect of which query you had submitted your earnest money?
In both the queries separately, Lordship. In both the queries separately. When both the queries, Lordship, separate cover, I have given the coverage.
Cover is not important.
Lordship.
For you had to
Different amount for each.
give different amount for each based on calculation. It is not that you have one.
I have,
and you,
Lordship,
solvency may be different.
Lordship.
Solvency issue may be
One document. Huh.
It is only qualification of a lordship bidder.
No.
Yes, lordship. That is a qualification of bidder. Lordship kindly, that's why lordship rule 27(7) is there. And lordship kindly for a moment, lordship, what is the requirement law? Lordship kindly say 27(5) for a moment.
See, the simple question is
Lordship.
that if you had fulfilled
Lordship.
the requirement under rule 27(4), all the things, including 3 and 4,
Lordship.
then it's all right. Otherwise, they did not have the choice.
Lordship. So I have qualified, lordship. Lordship kindly say the lordship kindly.
If you have qualified, then you will get the judgment.
Lordship kindly say the equality of the case, lordship.
See, Mr. Sahu has argued. You have also argued. Let us apply our minds also.
Lordship, another 2 points, lordship. Then lordship, Mr. Sir, Mr. My
Then
senior.
Mr.
Lordship kindly see what are the people in this case, lordship.
Sorry.
Lordship, they have declared me highest bidder, lordship. And also I have complied all the provisions they come up with, lordship, came up with the agreement. And lordship, during this period, lordship, because these facts have never brought to lordship. During this transit period, lordship, well, in between the agreement, the opponent lordship, the petitioner here, lodged a complaint before the Tahsildar that my man has utilized that source. Lordship, kindly say that these facts are never lordship. So that's why the Tahsildar, after declaring me H1, lordship, highest bidder, he cancelled my bid. Lordship, kindly comes to 27 for a moment. The Tahsildar in the entire lordship, the entire provision,
could not have.
the Tahsildar has never vested with the power to cancel any bid.
So have you challenged that?
Yes,
So you
lordship,
challenged
that
the
I
appeal.
challenged before the appellate authority.
Yes.
And lordship, that particular contents, because they made
appellate
allegation
said-
against me, I have utilized the source, that was tested by the competent authority. And lordship, I succeed. Then I went up to, they went up to High Court, lordship. Again, I also came to High Court because of that inaction of the state government not agreement. Then lordship, again, this honorable court directed, no, because they have not made party, this case may be press evaluated and a press hearing may be to take a press hearing. And while taking up such hearing, again I succeed. Then lordship, now they're challenging my order, which was subject matter.
You did not pass any order.
Lordship,
You had not passed any order.
no,
Pass
lordship.
in your favor. Yes, continue.
Lordship.
Yes.
But lordship, in this case, lordship, they have never challenged my declare for one thing, lordship.
All right.
And because I have been selected by the competent authority, both the bids, had it been a case, lordship, as per appeal 46
So you are saying that appeal had been filed by you and not by them.
they have not challenged my selection.
Yes.
Till date, lordship, they have not challenged my qualification and they have not challenged my declaration as a highest bidder. In my writ application, lordship, my appeal, they appeared and they are making some allegation which has been answered by the appellate authority. And now people can lordship kindly see. Two appellate authority. In such a case, two appellate authority has gone in my favor. And I have already the agreement. And they have declared the action of the Tahsildar is bad in law because Tahsildar has never vested the power under Rule 27 either to allow or to cancel the bid. It is only by the
See,
collector.
Tahsildar may not be having power.
Lordship.
The collector or the appellate authority may not be having the power. But this High Court has every.
No, Lordship, I am
will
not
see.
questioning. I am
We
not
will
questioning Lordship judicial Lordship.
yes.
But my
So
humble
we-
submission.
We will see.
And another peculiar point, Lordship, kindly note, because Lordship,
Yes.
Lordship, kindly see, at the cost of repeat, again I'm saying, the same situation, Lordship, they had faced last year, Lordship. They had not the required bank guarantee, Lordship,
That is a
solvency.
record. That
They
is
had
a-
challenged their disqualification before this honorable court.
Hmm.
And this honorable court, despite their disqualification also, considering the contents of the provision, because this entire act rules
Yes.
picks up
Yes.
only to augment government revenue,
Yes, yes.
and the only qualification, the highest bid will be given. What they had been given chance to participate. Lordship, they have taken advantage of out of the same benefits, and now they have one in challenging my
This
qualification.
is not
Lordship.
proper.
No, Lordship, this
On
is
their
not-
part, yes.
That's true, Lordship. My duty to bring Lordship's kind notice because
We will see.
if Lordship the permit, then I can give reply.
What reply?
Again, reply.
No, judgment. I want citing 2-3 judgments.
Give-
No, cite those.
Lordship. Only Lordship judgments. Lordship, but these two judgments covers the entire tender.
All right. Which
Field, Lordship. That is Lordship. I'm giving.
NG projects.
and this is
All right.
and this is recent judgment of Honorable Chief
Yes.
Justice. The recent judgment is very clear. They are relying the NG project judgment, Lordship.
Yes, yes.
Lordship, here, Lordship, they have very specific in the contractual matters, Lordship. When the Lordship can last perhaps 2-3 back, I was just to hear Lordship to
Yes, yes.
respond. Lordship was expressing because the mind, it has to be extracted by the state for the state revenue, Lordship. By this process, Lordship, there is no interim order. Still, I am, despite my, Lordship, I am the highest bidder and I am qualified in both the bids, Lordship.
How much money have you earned?
Lordship, no. Lordship,
No, you said you have operated.
only 5 months, Lordship. It is only, Lordship, I have only,
So you've exhausted by your fees.
Lordship, that is not.
Okay.
But Lordship, 5 months is nothing, Lordship. It's a 5 years lease, Lordship. Lordship. So if
You want more adjournment?
no adjournment, Lordship, Lordship can decide. Okay,
All right.
Lordship.
We ask the state if they have to say anything.
That I have, so far as the calculation is concerned, Lord,
Give your.
that has been, I have given that judgment, Lord. 2020 supplementary OLR 740, and this judgment has been upheld by dismissal of the SLP.
This one by.
And there are
ground
also
of
review.
limitation.
Thereafter, also review was filed before this honorable court and
Reviews are
that was
dismissed.
rejected. SLP was preferred and that was
Review also.
This will SLP dismissed on merit.
not merit, it was SLP dismissed. Only. Not interfere, not interfere in that.
Thereafter also review, my lord.
Review was rejected.
Review dismissed, thereafter.
Rule 27.4, Roman 4 was interpreted and calculation.
But that provision says for 1 year.
1 year.
Calculated for 1 year.
1 year.
one
1 year.
year.
calculation.
My lord, that is not dispute, my lord.
That is
Dispute
not- there
my
is
lord,
no
what is
dispute.
saying, what is the additional charge fixed by the authority? And what is the additional charge offered by the petitioner?
I'm
The-
not
the
doing
bidder.
that, Lordship. Now I'm going by their argument, Lordship.
That is
I'm not
dispute.
raising that contention. Lordship, can even that last day I was raising that point. Now I'm not.
That is the
I am
decision,
now
that
going
is
by
dispute,
their
my lord.
contention, Lordship. I'm going by their contention. I'm admitting their.
And your lordship can see that rule 27.4. The legislature has very consciously put the word below. Area or areas. Your lordship can see. So therefore, he has to deposit 67 lakhs. There is no deposit. You cannot interpret in this way that independently
All
the solvency is to be obliged.
I'm very interested. He has been successful in both the bid.
Yes, you made me qualify.
Both the bid.
You.
Yes, both the bids and you offered him.
Yes.
My lord.
I
And
have
he
also.
selected one, others you gave him the
He has not,
option.
he has never
You
opted.
have.
My lord, Tahsildar Rajab,
You have.
given my lord.
That is the requirement of law.
No, that is not
I'll
the
convey my
requirement.
acceptance.
All right. So some leave some argument to be made outside the court.
No, Lordship, outside your friend, Lordship, we do never argue, Lordship, outside. We have great respect to my
Yes.
senior Lordship, I never.
Yes.
E7.
Lord, my learned senior Mr. SP Mishra is on his legs. He will be here.
Yes, yes, you can start. Oh, he's for the petitioner.
Yes, ma'am.
You start?
My senior.
Avail this opportunity of his absence.
Is that right?
Yes. Yes.
Can I start for it?
37.
For admit the lordship. I was telling your lordship in the first hour, this is tender method relating to treatment system 2. It's a treatment system 2 for implementation of zero liquid discharge. Zero liquid charge system, including operation and maintenance for 5 years for sale. Petitioner was one of the bidders as per the tender that was floated. Petitioner company is a multinational company with 95 years of plant building experience in turnkey execution and operation of water and wastewater treatment plant both in municipality and industrial. Because water treatment plants in municipality also in industrial sector also, wastewater. The track record is execution of 6,000 municipal and industrial projects globally with quality and commitment of timely completion and delivery. The petitioner is India's leading water treatment company, over 3,000 crore annual turnover, more than 100 patents in his name, and is a market leader in water treatment in India. In 2022, when the tender was floated, amongst the 5 bidders, petitioner was one of the bidders, and petitioner was found to be L1. But the consultant was Macon. Your Lordship knows that in the tender matters, Macon is one of the very famous to assess to the competitive bids are concerned. And the Macon also recommended the petitioner should be granted, and the committee who considered is also recommended for petitioner's case. At that time, an objection was filed by one of the first bidder that I was debarred by Delhi Jal Board in respect of one of the projects. That was actually stayed by the Honorable Delhi High Court, and also after that I had executed 3 more big projects also. And that's the reason why.
So when was the order of debarment?
That was 2020, 15/10/2023. 20. But interestingly, they took the opinion of the Solicitor General. Solicitor General opined not to consider, though my case has been recommended. That was the subject matter of challenge before Your Lordship. In the writ application, the matter was thrust out, judicial review and everything was examined. It was found that that doesn't create a bar. I had disclosed everything for the authority, and the court honorably directed, no, he is found to be L1, his name has been recommended, and his case should be considered. Annexure 6, I have given the document also. The judgment is there.
Yes.
The operative portion of which is at page 95, if Your Lordship turns. It starts at page 65. Kindly turn to page 80.
Page
80, the judgment.
Yes. Yes, please.
It is paragraph 7, Malad. It
Yes.
is not disputed that the petitioner participated in the process of tender, was qualified both in technical and financial bid. Though he was declared as L1, but no LOA was issued in his favor. In addition to technical and financial requirement, eligibility condition contained the IFB, ITB, and biodata sheet of the tender document. The bidders were required to make an undertaking and declaration for compliance according to the company law. As per the bid data sheet under section B, the bidder was required to give a declaration as to whether the proprietor, partner, or director of the firm has any relation within the meaning of section 6 of the Companies Act, and any of the employees working in the plant, unit concerned, or director of sale including the subsidiaries. As per clause C, a declaration was to be given by the bidder as to whether it currently is serving any banning order issued it from carrying on business dealing with sale. As per the checklist under Answer 1, Section D, at serial number 14, the bidder has to give declaration stating that the firm is not blacklisted or banned from the business dealing by any organization. As per clause 29 IFB, the banning suspension firm supplied a contractor not eligible for submission of quotation or like offer against any type of tender during the period for which they have been suspended or banned. A business dealing or if submitted, those quotations offers will be treated as unsolicited and will not be considered. As per clause 14 of the checklist under Annexure 1 of Section D, the bidder has to give declaration stating that the firm is not blacklisted, banned from business dealing by any organization. The use of the word any has also its meaning, thereby requiring according to the circumstances may mean all, each, every, some, or any or more out of the several. In other words, it can be construed that firm is not blacklisted, banned from business, dealing with other organizations also. If the meaning of any will be given into consideration, the word any is defined in Judicial Dictionary of Words and Phrases, 5th edition John James, as word which excludes limited quality. But as has been extracted from Black's Dictionary, 5th edition, they have quoted those things, but I'll just not take the distance referred to here.
Yeah.
At page 95, let's kindly see.
Yeah. Yes.
Right. Para?
Page 84.
Page 84. Should I quote?
Also relevant to the constitution.
No, just tell me, when was the writ petition filed by you against the department order was dismissed by the High Court? Probably stay was granted by the.
So allowed.
No, as per your.
No, Delhi High Court.
I'll clarify, madam. Single judge initially granted interim order, then thereafter dismissed the writ petition.
Exactly.
In LPA, there was no interim order granted. And then
Here
they have withdrawn because the
court has
period
dealt
was
with the
over.
matter. So that matter is
Actually,
over.
that's the position.
So that matter is over.
So,
At page 95 or something.
That is not relevant.
No.
Then why have you stated all that?
No. I am referring to because saying that it has already been thrust out and the Honorable Court directed that it should be given. Page 95 kindly. That is why I am referring to page 95. It starts 4th line, Maran. When
No,
judicial
19
power is
the-
exercised
The Supreme
and
Court,
authority.
this court, the division bench has held nothing except that the division bench says that the decision is not backed by reason.
Right.
So, and therefore this court interfered with a direction to consider. If there is any finding that you were otherwise eligible and thereafter the reasoning is to be given, then the matter is different. So is this your case that there is any finding recorded by this court in the division bench that you had the eligibility? If there is finding with that is binding.
Yes, I am eligible.
According to you may be eligible according to you. You may be eligible according to the judgment.
Judgment, right.
So how do you say that according to the judgment you are eligible?
Sir, what I say, they tried to deprive me to get the award. Therefore, I challenged it. The Honorable Court said, I am eligible. Therefore, I should not be deprived of. My case should be considered because I am the L1 and my name has been recommended. So I'll pause here a moment, Bharat. If Your Lordship kindly have a look at paragraph 11 of the counter, page 123, it starts.
35 or 38 printed.
No, please come again to that that part of the judgment.
Yes.
Where this court has held about your eligibility.
Eligibility, Bharat.
Yes.
But if Your Lordship kindly turn to page 95.
This is about Supreme Court.
where judicial power is exercised. If your lordship, when it starts from when judicial power is exercised by an authority normally performing executive or administrative function, the Supreme Court would require to be satisfied that the decision has been reached after due consideration of the merit of the dispute, uninfluenced by extraneous consideration of policy or experience. And this court insists on disclosure of reason in support of the order on two grounds. One, that the party agreed by a proceeding for the court has the opportunity to demonstrate the reason which persuades an authority to receive a case were erroneous, and other that obligation to record reasons operates a deterrent against the possible arbitrary action of the executive authority. In view of the aforesaid fact circumstances, order impugned dated 10/6/2023.
Let us come back again to the date of the tender notice. 2022, what is the date?
19/7.
19/7/2022.
19/7/22.
And when was it rejected? Your
10/6/2023.
10/6/2023, the technical evaluation was done. So, but then you were suffering from this blacklisting order
So
on 10/7/2020.
ban order, sir, only, so the ban order only confines to the departments concerning Delhi. So they have indicated that.
Who? See, it is not that it is not that the authority which is blacklisting you, that authority is bound by that order. Any authority awarding contract may take into account.
So there was a stay order.
But Mr. Mishra, how can that authority direct others not to consider your tender? That is up to the other authorities. That is up to them.
So the order of blacklisting was there against you.
Sir, on the date of submission, I had a stay that has been dealt with here in this matter. But here actually that is not the issue before your lordship right now. Right now the issue is that then after the court, honorable court directed to consider, they wanted me to extend the bank guarantee. They wanted me to extend the bid price period. And I extended for 6 months. After 6 months, they cancelled the entire tender. And after they cancelled the entire tender, 2 days thereafter, floated a fresh tender. I challenge this before your lordship, my lord. Your lordship issued notice. Your lordship passed an interim order. Subject to result of this writ application, if they can do anything, they have to do.
So it is this writ petition? Or?
Yes, in this writ application. But after that, what they still proceeded with the bid process.
Well, subject to result.
Subject to result.
Yes.
So I participated without prejudice. But those persons who participated here, they also participated in this fresh tender. But what happened? The same tender. There is no change at all.
Mr. Mishra, on what ground you are challenging cancellation of the tender process?
Here in the present case.
Yes, yes.
But present case is that number one, my case was to be considered. They have not considered. Secondly, they have cancelled on the ground. They have taken in paragraph 14 of the counter affidavit. Though no reason has been given to communicate me. Paragraph 14 of the counter. It starts at page 123.
They have given substantial increase in the cost of the project.
So that is the exact point, Madam. But the price, kind of see, I have given a table in the additional affidavit, which your lordship can see.
No ground,
Let me take your lordship to paragraph 11 first, at page 126. Kindly look at page 126. Pursuant to the tender notice, at page 126, Madam. Pursuant to the tender notice floated by the opposite parties by tender notice number 19/7/22 for treatment system 2 under implementation of zero liquid discharge system including operation and maintenance for 5 years at Rourkela Steel Plant, Rourkela, Odisha. 10 bidders, including the petitioner, participated in the pre-bid discussion. After 3 extensions, tender was opened on 12/9/22. 5 bidders were received from number 1, Gaza Engineering Private Limited, who is also a bidder in the subsequent one. Basis Triveni Engineering Industries Limited, participant, and VTech, that is the present petitioner. Consortium IFA Infra Research, who is also one of the bidder here, and consortium
in the
Techno
present
Engineering.
proceeding, in the present proceeding, Mr. Mishra, the cancellation of the tender process is under challenge.
Yes.
Nothing more than that.
That is the challenge under challenge.
That is the only thing which is under challenge.
Yes.
Yes.
That is the subject matter of challenge. But you must kindly see that paragraph at page 1. I'm reading. The price bid, it refers to the previous one. The price bid was opened on 18/11.
Yes.
The price bid was opened on 18/11/22, wherein the present petitioner emerged as L1 bidder with their quoted price 216.49 crores.
Yes.
The project tender committee, in its meeting held on 7/12/22, after perusal of the price bid evaluation report submitted by the consultant Mekon, recommended for of the order of the L1 bidder, the present petitioner.
Yes.
Para 2, subsequently a complaint was received of the opposite parties against the present petitioner about debarment by Delhi Jail Board. In this regard, an opinion from the learned Solicitor General was sought on May 2023. Based on the opinion of the Solicitor General, the bid of the petitioner was not considered, which was communicated to the petitioner on 10/6/23. That was also not communicated, but that doesn't matter. In the meantime, judgment dated 8/8/23 of this passed in WPC 19399 of 2023 was passed, received by the opposite parties, wherein direction was made to consider the bid of the submitted of the petitioner company for award of work in his favor. Accordingly, the offer of the petitioner was put up before the board of the opposite party because of high value contract, as the project was 218.95 crores. So my price quoted was, it was 16.49. The price of the work was 218.95, is less than that. It is humbly submitted that sale board of the opposite party, after due deliberation, observed that there has been inordinate delay in concluding the tendering process, and there has been substantial increase of 40% in the cost of project over stage 1 approval cost as per ITC and GTS basis. Therefore, the board of opposite party, taking into consideration the aforesaid fact, decided to subject project proposal may be retendered. This decision is the best financial interest of the opposite party. For a pausing here and moment, if you also kindly see, but again, 6 bidders were participated. So kindly turn to the additional. I'll show the table, then I'll come back. The additional affidavit. Filed by the petitioner, the counter has been filed, showing the table.
Additional affidavit you have filed.
Sir, kindly see the reply to the additional affidavit.
Yes.
There, the paragraph 7, you should kindly see, sorry, paragraph 8. In paragraph 8, I have given a table.
Yes.
The first table shows the first tender that was floated, the price quoted by all these persons 1 to 5. Gaza Engineering, Triveni Engineering, VTech, and then Consortium Infra, Consortium Techno Engineering. If also looks at L1 is the project petitioner. All this bid amount has been quoted here. Kindly turn to the next page, sir.
Yes.
I have given the comparative chart.
Yes.
But at that time, the price bid in the previous tender was opened. So my price was known to all those who participated in the earlier tender. It's the same project that is to be undertaken. But I have quoted previously 216. Now due to inflation, I have quoted 219.92. Gaza quoted 231. Subsequently quoted 195. 232 is Triveni, is get 214. They reduced their quotation. And this IFWA, who is now L1, also reduced 251, then 194. But does this help and show 40% rise in stage 1? Now they anticipated it should increase. That is the loss they want to sustain. But they knew my price, reduce their price.
See, Mr. Misra, there are two aspects.
Yes, madam.
The loss which they are suffering.
Right.
You have not come for that.
So they are not suffering any loss that I am to prove.
No. They are suffering because of their action.
Yes.
The loss which they are suffering because of their action, according to you, you are not concerned with that.
No, not concerned.
You have interest in your own interest.
Correct.
Of getting the award of contract.
Absolutely.
So that is another aspect, whether the government, it's a public interest, this thing. We shall examine that also.
That's a public interest, madam.
Yes.
But one thing actually haunts my mind. Let's kindly, what exactly I want to think loud. But once an order has been passed by the Honorable Court, rightly or wrongly, if it's the wrong order, this should have been challenged.
No, that order cannot be said to be, at least that order can never be said to be wrong by this court.
What I mean to say, what I mean to say, if they are not supporting the judgment, they should have challenged it, number one. They did not challenge it. They accepted the judgment.
There is no question of acceptance. The question is, had they proceeded with with that tender process without considering your case, the matter would have been different. But they have cancelled.
No, they have not cancelled. So interestingly, they passed no order. That is exact.
No, whether the tender process has been cancelled or not.
So tender process cancelled.
So the tender process, that order has become useless for your purpose.
Sir, what I think I couldn't explain.
Right.
What I wanted to say, once the court directed to consider, they could have said, no, we have considered and we don't accept. This is one part. They should have said, sir, we are going for a fresh tender. They could have filed an application for modification of the order. To the Honorable Court saying that, sir, we don't accept now, we are going to suffer loss, so we'll go for a fresh tender. They did not do that.
So this is your case that if they wanted to cancel the tender, they should have sought leave of this court.
So what I wanted to explain myself, but they did not challenge the order, they accepted the order.
They have accepted the order.
Right. Once they accepted the order, they should have considered my case. But they have not considered, they have not communicated that they have considered and found that it is, they are saying it in the counter affidavit. So let me speak aloud. They are considering and saying that we have considered in the counter affidavit, which they have not communicated to me. Now, for the first time in the counter, they are saying 40% loss in stage 1, and therefore we did it. But same tender, 2 days after, they said that we have cancelled the tender, floated a fresh tender. Waited for 6 months after the order, wanted me to extend my bank guarantee, wanted me to extend the period of the price bid, and I extended it. Then we requested them to please comply the order. I am waiting for the last 6 months. Honorable Court's order is there. You have to obey the court's order. Court order has got a sanctity, madam. It has its own sanctity. You cannot just ignore the court order saying No. Even if the court order has passed, we'll cancel it.
Cancellation.
There is some sanctity to the court order.
Cancellation is a different exercise, Mr. Mishra, altogether. Cancellation, you cannot.
So here escalation is not there, with due respect. Sir, I increase my, because there is inflation. 1.5 years have passed.
Without cancellation, how can there be a first tender process?
So inflation will take, because
Cancellation, whether the tender has been cancelled or not.
tender has been cancelled. So the tender has been cancelled. One cannot cancel the tender when the process has gone to that far without any justifiable reason. Reason in the sense, sir, I have contested litigation. Maybe it's a deliberate attempt to deprive me. That's the reason why a fresh tender has been called. And the persons who quoted more than me in the earlier one, which is a competitive bid, they had not known my price. Now, after my price has been disclosed, now they give a lesser price.
The prices of others must also have been disclosed, not
Yes.
only yours.
But that is, their own price has also been disclosed.
Therefore, according to you, now since they had floated the tender, and now because there is an order, and on the basis of that, they were bound to award the contract in your favor.
Yes.
That is impossible. That we cannot do.
So that is one of the reasons why I say, they found a person who is L1 after knowing my price bid in the previous tender. They have reduced for the same work. But kind of conscience says anyone wants to bid, he cannot reduce it. If he reduces, but that itself shows it's with some intention to deprive somebody else. The same project cannot have less price. One cannot, as such, cannot quote a lesser price for the same quotation which they have quoted earlier. It may be more. And the anticipation was sale was more.
No, you don't know. In the meanwhile, they might have acquired some technology, and based on which their investment might have been less. We don't know. And you are right. When they learned, it must have been made public as to who quoted what.
Exactly.
So it's a competitive market. Someone might have quoted less.
So that is the basic reason for which actually I am before a lordship matter, that once my bid has been opened.
So therefore, if we accept your submission, then the opposite parties have no other option than to award the work in your favor.
In fact, they try to avoid. In fact, the reason being, they kindly say they want a good work. They want it should be, but with the reputation I have in the market itself is much better than comparison to others. But I have 95 years of experience on that. 95 years. But that's the reason. If your lordship looks at, come to page 128.
What is there?
That I read that, sir, another aspect can you see. If for my bid, they wanted an opinion of the Solicitor General.
Why were you going into such things? Opinion of Solicitor General, those are irrelevant considerations. They relied on the opinion of the Solicitor General. It was open for them to rely or not to rely, to accept the opinion or not to accept the opinion. Those aspects are immaterial completely.
So cancellation of the tender.
Cancellation of the tender is the issue. Cancellation.
I am on the issue of cancellation.
Yes, we understand. So we understand cancellation. See, you are challenging the order of cancellation because there was some order in your favor.
Right.
You are challenging the order of cancellation because you had quoted the price which had become public.
Disclosed. And now the fresh bid, they have given lesser price. And that fresh bid is subject to result of the Honorable Court. I also participated without prejudice to my. There's no deprivation. But there is one decision, if you kindly see.
Yes.
Division bench decision, this Honorable Court, which is close to.
Division bench decision of this court. There have been so many decisions of the Supreme Court. So, on this point, Which decision? Which, oh, so many decisions, Mr. Mishra. Yes.
I'm giving a decision note that I have referred to some decisions. You should kindly have a.
Which is the decision of this court? You have-
That is last page 30. Page 38. 30. Copy there.
There is no page 58.
Hey, Ganesh.
That is Sikal Logistics.
Yes.
Mahanadi Courtfield, the reverse auction process, including the petitioner. Inverse auction process, which took place on 4/11/2016, the petitioner emerged L1, having quoted the lowest price and was declared L1. As a result, the price quoted the petitioner in its price bid was made public and published. And after being declared L1, the petitioner requested on several occasions to opposite party to issue letter of acceptance.
It is not reported.
It's not reported.
Must have been reported. AFR.
AFR there.
So what is the law which has been laid down?
It has been laid down that number one, the cancellation of tender without any reason is absolutely illegal and opposed to law. And secondly, it has they cannot improve the reasonings in the counter affiliation
of tender requires reason.
So reason means they must justify why actually it has been cancelled after so many battle of litigation was there. And also it settles the law that once my price bid has been opened, here also intervention was there, and one of the party who was successful in the subsequent tender, he wanted to participate. That was also not accepted. If you also look at page 19, the intervener contained the pursuant to subsequent tender.
Yes.
It had quoted lowest price than that of the petitioner, quoted pursuant to the earlier tender 13/10/2016.
Yes, you are
But
right.
that itself cannot be a ground.
Yes. So whether this order was challenged?
This order, to my knowledge, it has not been challenged.
Let's examine. Yes. So this is the first decision which we had filed an appeal.
So I was told that state has filed an appeal and this has been confirmed.
State Mahanadi
MCL.
party.
from the
MCL.
state file.
MCL.
must have filed appeal.
MCL.
Yes.
So kindly, I have given a note of legal submissions. madam.
All right. Yes, it is there.
I have indicated those decisions. If you also
Yeah.
kindly see, no reason has been assigned for cancellation of the tender.
Yes, these decisions have been taken into account in case of that Sikal Logistics.
Sikal and I have given other judgments also. Other judgments also I have given. But if your lordship turns to serial number B, AB, what is reason order also I have given some decisions.
All right.
And your lordship also in that other tender matter which your lordship delivered. Rosemata, your lordship dealt with those things also.
So what have we held? We don't remember.
The judicial review in tender matters, my lord. Rosemata judgment again. I have referred to Tata Cellular case 1994, volume 6, paragraph 70 and 73 that often quoted. It cannot be denied that principle of judicial review would apply to the exercise of contractual powers of the government bodies in order to prevent arbitrariness and favoritism.
No.
But here, arbitrariness is writ large in the face of it, in fact.
Yes.
Then Ronak International and Subodh Kumar Singh Rathore, those two decisions also I have given those judgments also to the Lordship.
Yes.
Then D, if your Lordship looks at that discretion of a public authority cannot be unfettered. Though the discretion lies with them to reject the tender, it
Yeah.
cannot be unfettered.
Yeah.
Paragraph 32, they have said the expression is of opinion that substantial modification in the draft development plan regulation are necessary. Our considered opinion doesn't confer any unlimited discretion on the government. So that is quite evident.
Yeah.
Then arbitrators have given the judgment of East Coast Railways,
Yes.
2010, volume 7, SCC 678.
Yes.
That one of the most fundamental principles of rule of law recognized in all democratic systems is that power vested in any competent authority shall not be exercised arbitrarily. So the power exercised that doesn't lead to any unfair discrimination.
Yes.
And arbitrariness in the making of an order by an authority can manifest itself in different forms. Non-application of mind by the authority making the order is one of them. Every order passed by the public authority must be disclosed, due and proper application of mind by the person making the order. This may be evident from the order itself or the record contemporaneous maintained. An application of mind is the best demonstrated by disclosure of mind by the authority making the order.
Yes.
And any disclosure is best done by recording the reasons that led to authority pass the order in question. Absence of reason either in order passed by the authority or in the record contemporaneous maintained is clearly suggestive of order being arbitrary. And then sanctity of the court order. I've given the judgment of Karnataka High Court.
Yes.
Paragraph 11, when an order passed by this court, it is to be considered by the public at large, same concluded at the instance of this court. Then it is the duty of the court to give respect to its order by giving sanctity more than over and above the highest bid. The cases cannot be concluded if for one reason or the other, as stated in this application, the orders are recalled and there is no end. This court cannot put an end to legal proceedings. This court feels by considering all these applications used to real estate business, one is not the criteria sanctioned for order in criteria. But once this honorable court directed for consideration, they could not reject it. They tried to overreach the court's order by cancelling the tender. In the process, they actually cancelled my bid. Then subject to outcome, you Lordship passed an order, if you Lordship kindly see, subject to result of this writ application.
Yes.
Order dated 22/2/2024. In this present case,
Yes.
on 22/2/24, you Lordship passed an order that any steps taken will be subject to the result.
Yes.
Because I challenged immediately before your Lordship. So what is the outcome of this subject to result? I have given a decision to that effect. If you also can take note of Bhubaneswar Sahu versus Union of India, that is of Chhattisgarh Bilaspur Court, my lord. The appointment of interveners have been made pursuant to the interim order 29/8/2023 passed by the Honorable Supreme Court, in which the appointment is subject to the outcome of this petition. Therefore, right accrued in favor of the interveners. What do I beg to submit, my lord? Therefore, the subsequent tender and the persons who participated, but they cannot claim as a matter of right that once the subsequent tender has been done, therefore we should be given the benefit out of it because we are at a loss. We participated without knowing it. But those are the persons who also participated in the earlier tender.
No. But how do you say that
they participated?
They have no any. Though, are you suggesting that because of that order, interim order,
Yes.
the interveners do not have any locus standi.
Intervener cannot claim any equity, saying that
That is different. That is different. It's all right.
and I have also given those decisions of legitimate expectation, Lord. Here I fought the litigation. I succeeded in the court. That was not challenged. There is a specific direction to consider my case for grant of award.
See, I think that clause has been quashed by the Odisha High Court only, by bench, where it provided that if you have any litigation, then you are not eligible to participate in the tender process.
No,
There was,
that was the Rosemata case.
I don't remember.
Oh no, Rosemata case. Your
Senior
Worship.
succeeded in that matter.
Yes, yes. So that is the reason. Because you file one writ petition, you succeeded there. Then you have filed this writ application.
In fact, not those.
So therefore, possibly because of these circumstances, they were compelled to incorporate a provision that those having litigation of any kind.
So as a matter of fact,
On a
this
lighter
honorable
note, Mr.
dealt with this matter, say that no, I am not ineligible.
All
I
right.
am not ineligible.
All right. All right.
Therefore, that may not stand. Rosemata may not stand in the way to that finding and observation. But there actually, Your Lordship also dealt with. I have disclosed, and that doesn't stand as a bar. The
That is
clause
what
they
I
have.
was not remembering. That is the case. That was the
That's
case.
the case. My
Sir,
learned senior
Rosemata, the
succeeded in
specific
that.
clause was incorporated, which was deprecated. Your Lordship deprecated in the Rosemata case.
Yes.
I'll not take much time. This short list of dates, I'll just quickly.
Yes. So we have to take up one matter that we cannot leave.
5 minutes by the clock. I won't
Yes,
take
yeah,
more
okay,
than
okay.
5 minutes.
All right, please take your time.
List of dates, serial number A is the name of the work for your Lordship's convenience. Thereafter, my Lord may kindly see 18/11/2022 in the first round, the bid of the petitioner was 218 crores. And there was a complaint, and thereafter all these facts have been narrated. Now, what would be important would be serial number M at page 4. On 22/2/2024, in this writ petition, this court passed an interim order saying that it shall be subject to result, and any development, if it takes place, they can come again. Thereafter, corrigendum was issued extending the bid. The petitioner thereafter submitted its bid. So after filing the writ petition, they submitted the bid on their own. There was no express leave of the court. Be that as it may, my lords, the important point that I'm trying to make out here is at serial number T, page 6. Subsequently, there was a full stay order saying that you can process the tender but don't finalize it. So as on date, that order is operating. So we have the financial bids before your Lordship, but we cannot finalize because of the subsequent interim order by a coordinate division bench. Now, what would be important would be serial number T, 4/6/2024. The financial bid was found, and the petitioner was not the lowest bidder. This line is important. It was found out that the petitioner was not the lowest bidder in the second round of tender, and by floating the second round of tender, SAIL has saved a sum of rupees 21 crores 98,51,300. In case the present petitioner is awarded the contract and the present writ petition is allowed, the loss to the public exchequer would be to the tune of this much. And the following at the details of the different bidders. So this would be the public interest element. That's why I wanted to just lay emphasis on this. And I would start from where my learned senior left. My lord, if my lord sees the figures of all 5, rest of the 4 have all reduced. Had it been a case of single person reducing, then this question of malafides might have crept in. Here, across the board, there has been reduction. So there cannot be any question of malafides. And my lord knows in view of Jagdish Mandal and all those judgments, unless they're nullified, the courts normally should not interfere. Those judgments are given along with paranouns. So this point, we have mentioned it here also at page number 8, that cancellation of the tender was in public interest. There was
All the bidders reduced, including the petitioner.
petitioner increased by 3 crores odd.
Petitioner has not.
Across the board, all other bidders reduced. That's what my learned senior's table says. So that itself would makes out a case for us that it's not backed by mala-fides. We are not favoring a single person. So that table of my learned senior itself works in our favor. If there's a reduction across the board, then how can you allege fines? Had it been a case of single person reducing and us favoring, then it would have been different. So I just try to draw a point from his table. It's not that that's the only point. The main point here is by this cancellation, we have saved around 20 crores. And apart from that, there was other issues for which we have come up with this. So this point I have mentioned at page number 8. And I'll just quickly show that paragraph Jagdish Mandal, my lord knows.
When was the writ petition filed?
21/6/2023. At serial number F, I have given the list of dates.
And when did he submit his tender?
He submitted his tender 19/3. After the interim order was passed by this honorable court, saying that it is subject to outcome.
19/3.
19/3 at serial number O.
19/3/2024. 24 he submitted the bid. And interim order was passed on?
Prior to that.
22/2/2024.
22/2/2024. So did you seek any leave or did you inform?
Sir, actually, I filed an application at the time when I applied. Kindly have a look at annexure 14.
Oh, I thought it has been granted liberty. Actually, it is at
just a minute.
liberty to approach this court seeking any interim order, not liberty to
So
participate.
there is no express leave. So there one judgment of the Supreme Court I have got that this is speculative in nature.
Page 160, you know, wanted me to. Page 164.
Yes. Yes.
When I submitted the bid, I also mentioned that at page 165.
Yes.
Without prejudice, we are in writing you in continuation of our previous correspondence dated 1/3/24 regarding the ongoing case number so and so before the Honorable High Court of Orissa, the associated, despite the acknowledged existence of sub judice nature of the pending writ petition, the order dated 22/2/2024.
So you participated in the tender process
without prejudice to my right,
to the-
because I have indicated then that the interim order is there, and in spite of the interim order, you are proceeding with the tender process and participating without prejudice, bringing to a notice about the pendency of the litigation also.
Yes.
So, my lord, our point regarding to persuade a lordship, this may be speculative. Because first there's an interim order on 22/2/2024 saying that this shall be subject to outcome. Then he participates without express leave of the court. But while submitting in tender, he says that it's without prejudice. So just to persuade your lordships, if those paragraphs may be relevant, of 2010 10 SCC 422, paragraph 44. These are just persuasive.
Which
I'm just giving the tendering that copy. That's not in the note.
What is the citation?
2010 10 SCC 422.
420.
422. Only the relevant paragraphs, if I can place, paragraph 44. This would be maybe relevant in the context of this case. It says, in an action of law, is an action of law a game of chess? Can a litigant change and choose its stand to suit its convenience and prolong a civil litigation on such prevaricated pleas? Then this doctrine of election they have analyzed. The common law doctrine of prohibiting approbation and reprobation is a facet of law of estoppel and best established in our jurisprudence also. Then they have said that a party in his own mind has that he would choose one of the two remedies, even though he has written it down on a memorandum.
Yes.
Then the English judgment at para 47, that one line may be important. If a man once determines his election, it shall be determined for him. So this may, just to persuade regarding waiver, so far as merits, my lord knows Jagdish Mandal, para 22, which is at page number 59 of that compilation.
Yes.
Again and again, the relevant paragraph portion I'm just reading out. The tenderer or a contractor with a grievance can always seek damages in a civil court. Attempts by unsuccessful tenderers with imaginary grievances, wounded pride, and business rivalry to make mountains out of molehills of some technical procedural violation or some prejudice to self, and to persuade the courts to interfere by exercising power of judicial review should be resisted.
Yes.
This has also been repeated in NG projects, which also I have given at the last para 23, which is at page number 18.
Yes.
NG projects, my lord, has seen that again. Para 23 of NG projects, the relevant portion is at page 89 of that compilation, towards the bottom.
Yes.
So public interest has also been analyzed. Here it is in public interest, we are saving around 22 crores if we go ahead with this step. So this will be all. I have given all the paragraphs. In the first page itself, I have given the judgments along with para numbers by itself.
Yes.
Grateful to you.
Reserve. Reserve.
Can I see the reply or 2 minutes? Sir.
Yes.
So all these judgments have been taken into consideration in the judgment I cited before Lordship.
Yes, the latest judgment by Honorable Mr. Justice Partiwala.
Subodh
The latest one.
And also the judgment should have Subodh Kumar Singh Rathore, everything has been dealt with here. I have also cited that decision.
Yes.
And also the decision of Justice Sadangi Marat, which I just similar to the present case. They are always Michigan Rubber and Jagdish Mandal and Ronak International also been quoted, saying that this is a case where courts should not interfere, save and except where the arbitrariness, nullified, everything writ large in the face of it. But if your lordship kindly see, but I filed an application saying that I participate without prejudice to my right. There is an interim order subject to result. Kindly take note of that, then I participate. But this participant is also subject to result of the writ application. But they could have taken leave of the Honorable Court when they wanted to take the subsequent bid, cancel the tender. That no, we cannot consider this case because there is such difficulties are there. They delayed the matter. After the order was passed by the Honorable High Court, 6 months period they took to take a decision, saying that now we have cancelled. But now they cannot turn around and say that we are at a loss, because they are not at a loss, because supposing tomorrow another tender will be floated, and maybe other bidders we can quote less. That doesn't say it's public interest that they're saving money.
We don't know. See, there are no set rules. After all, it's a work
subject to result of the peculiar case. Correct. There is no
have this
rule.
liberty.
But here the question of that they are going to save 21 crores is not correct. The reason being, merely because the person has quoted less.
That is they are going to save, or they are going to spend more than.
Not to be actually considered for this to show that their conduct throughout to deprive the petitioner. As your lordship said, maybe they could not succeed in cancelling my tender in that debarment due to the reason of debarment. Now they do not want me to be there. But that cannot be a ground. Once the same has been tested in the court of law and there is a specific direction, court order has got a sanction. It amounts to discrimination.
We will see.
Yes, I am appearing for the-
And there is no change in specifications over the tender is concerned, same tender.
So I'm appearing for the successful that was implemented on my lord's directions by this honorable court, my lords. This judgment, I'll just fax your lordship, my lords, nothing to be said about that. One extra angle, my lords, which has, my lords, it struck me as, my lords, maybe quite interesting, is 2022, volume 6, SCC, page 127, that NG Projects Limited versus Vinod Kumar Jain. Two sentences, my lords. Paragraph 23. If the court finds that there is total arbitrariness or that the tender has been granted in a mala fide manner, what exactly my learned senior was arguing, still the court should refrain from interfering in the grant of the tender, but instead relegate the parties to seek damages for wrongful exclusion rather than to
Yes,
injure.
that is what Justice Honorable Mr.
That same judgment, same as these three lines are also. Insulation against any possible loss suffered in a claim, so they may be delegated to that. And I am, my lords, I am now, as on date, the facts which stand as on date, my lords, I am 22 crores lower than the.
So paragraph 39 and 40, the Rosemata Lordship delivered that judgment, my lord. So kindly have a look at that.
That was on a very limited point.
Paragraph 39 and 40.
These are general principles.
There was a specific clause which deprived me to apply, which is contrary to the public interest and public policy.
Yes.
Your Lordship dealt with all those judgments in that judgment also, very detailed, elaborate judgment.
No, just to clarify, here in this case, there is that not that omnibus clause is not.
No, it is not.
Here it's specific. And that point is no longer there now.
No, in fact, I was making that observation. You can say that mischievously. That maybe this is the reason why they are. In fact, you file one writ petition, then you file another writ petition, then you will be filing, going for arbitration. So maybe to avoid you.
Exactly, that is the mischief.
Now,
That should not be, but that is nullified.
I'm told they are no longer keeping clause for arbitration also, they are not keeping anymore, becoming too expensive.
Arbitrariness and nullified.
The Odisha government.
Some PSUs have started.
They have now done away with that clause, arbitration clause.
Like the
In
other
fact,
one,
my
you
lord,
said,
Delhi High Court judgment while dealing with the case cited that banning that
in
the
public
petitioner's
interest,
case
you
in
get
the
the
other one,
best one.
has
It's not the
categorically
price,
said
is not the
that
criteria.
the observations of the court will not affect the arbitration, which had since attained almost reached the final stage. And thereafter, the appeal, LPA there was no stay, and the LPA said that we are not going to interfere because a procedure for cancellation department has been followed.
Yeah, sorry for troubling.
And just one more judgment, my lords.
Council is sitting.
No, you have been mentioning since 3 days because this is an environmental.
Another person mentioning since 5 days.
Just one more judgment I'll cite on the cancellation, the power of the authorities to cancel, my lords. I'll just the paragraph.
One more, last one or more? Last one.
Last.
Yes.
This is, my lords, paragraph 13, 12, 13 to 15 and 23.
That has been referred to in the earlier judgments also.
Yes. CW is Soma
This is
Consortium.
after disclosure,
Yes.
the price bid of those persons should not be considered at all. So that amounts to depriving my opportunity is lost, and
All right, we will consider.
right.
Great.
Grateful to you.
I'll give that citations for it. Tomorrow, I'll look up 44. But the list I have given,
Item 44.
Please notes. This writ application in the form of public interest litigation. The application is properly constituted as per by virtue of my lord's order dated 16 February 2023 in WPC number 4439 of 2023. The issue was involved was regarding irregular assumption of charge by the opposite party number 2, that is registered.
Rejoinder.
Yes, ma'am.
So what is the urgency?
Urgency is that since last 1 year and a half months, the post of the in view of assumption of charge by the opposite party number 2, the provisions on section 70 and 112 of Orissa Cooperative Societies Act 1962 that is has become ultra virus.
Action has become ultra virus, or the position appointment is ultra virus?
No. The
Provisions.
the forum has become defunct. It has created a vacuum in that region.
So there is someone functioning or no?
No, madam.
Yes, where is Mr.
My lord, my only submission before lordship, kindly have a glance to paragraph 7 of my rejoinder affidavit. The legal points which I have raised, that is with reference to section 3.
Yes.
As per section 3, the registrar of cooperative society is to be appointed by the opposite party number 1.
Mr. Counsel, it is not that the position is vacant. You are challenging appointment of someone.
My lord, in view of unilateral assumption of charge by the opposite party number 2,
Yes.
the forum falling vacant since last more than 1.5 years.
Reference to above statement of oath by the opposite party.
And this aspect has also been established in view of the counter filed by the state government. My lord.
I have the judgment has been delivered by me also on this point. No.
Regarding taking that.
Supervision of the Orissa Cooperative Society. Or RBI something was required.
So then somebody was kept in charge after he was removed by the High Court again.
Where is the decision?
My lord,
We recently have delivered a judgment in 2024.
Regarding the violation of my lord's order, it is established under the annexure D filed by the state government, my lord, page 20. The last sentence of the annexure, this office may please be intimated that if MD of your bank has never been moved to proposal file for convening the meeting, if any, further, the hour was to initiate steps for recruitment of as per the existing provisions, but instead.
Let him, he must have an opportunity to reply to your submission. We will take up the matter on Monday.
May I prefer within past 5 cases?
Yes, we'll take up. And do you have any idea that in one of the cases, with similar matter has been decided?
That was pertaining to this very matter, Your Lordship, wherein Your Lordship, earlier Your Lordship, as per the Your Lordship direction, the managing director charge has been assumed by the Registrar Cooperative Society, Your Lordship. Thereafter, the matter was called, and since the
yes, that had become infructuous.
Yes, Your Lordship.
That matter had
Somebody else has been appointed.
Because
and the petitioner is alleging non-compliance of the order in the very case, which case has already been declared infructuous by this honorable court.
No.
What is
already we will hear.
Your Lordship, may proceed to Monday, Your Lordship, Mr. Author will address.
May I prefer?
I thought there is some very extraordinarily urgent matter. Monday.
Within past 5 cases.
Yes.
Deeply.
Yes.
Item next. May I pray, my lord? I'll come prepared with a note. Can it be called 1 week after? After a week.
All right.
Item 16, my lord. Yes, I have to take instruction. What is the latest position? 16.
About?
About what is the latest position? Because it's 2012. That was in respect of so far as IDCO is concerned, that money has been paid and everything has been cleared.
Next Thursday, next Thursday.
My lord, 1 week after. After puja,
1 week, 1
because
week.
he's suffering.
All right.
His son
All
is
right.
suffering and he is in Mumbai in
All right.
1 week after.
All right.
Obliged.
All fresh admissions next. Much obliged.